Madam Co-Chairman, you're ready. Would you like me to
Ms. Swan. I'd like to call this meeting on the Select Gaming to order. Would LSO please take roll?
Yes, ma'am. For the Select Committee on Gaming on August 7th, Representative Johnson,
Present.
Representative Webb,
Here.
Senator Crago is excused.
Excused.
Thank you. Senator McCune,
Excuse for the moment. I think he's still traveling.
thank you. Co-Chairman Cole, you are present, and Co-Chairman Lee. Yes, ma'am,
Here.
you do have a quorum.
Thank you. I'd like to entertain a motion to adopt the minutes from our previous meeting.
So moved.
Do we need a second, LSO? Okay.
Those minutes have been adopted and approved. And then,
All in favor?
all in favor, please say aye.
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 Those minutes have been adopted and approved, and we'll move on to the Spectrum Gaming report. Is there someone here from Spectrum that could come forward?
Madam Co-Chairman, I am in the process of bringing them in. They are online. So as soon as they are able to turn on their cameras and mics, you should be able to hear from them. In addition, they do have a presentation which I'll be running from here.
Good morning.
Good morning. Please introduce yourself for the committee.
Yes, good morning.
And proceed.
My name is Matthew Robe with Spectrum Gaming. I'm the Senior Vice President of Analysis and was primarily concerned with the market sensitivities in the report we performed last summer. Ted?
Hi, good morning. Ted Grove, Spectrum Gaming. I concentrated on law enforcement and regulatory matters for the report.
Thank you for coming today. Please proceed with your presentation.
Good morning. Pleased to be here. Are our slides available to you guys? Karen, did those get distributed? I know Nick was going to get them to you.
Yes, I do have the slides. If you would just let me know when you want to bring that up and when you want to advance slides, I can do that for you.
Sure thing. Why don't you bring them up right now? Please. Terrific. Thank you. And then go to the first slide, please. Good morning. The important thing that we determined was the strength of the market availability for HHR in the state of Wyoming. We felt that there was about $400 million of revenue available in the marketplace, primarily, excuse me, due to growth from Utah and Colorado. And as you can see, if you look at what's happened in the last 12 months, the June 2024 revenue for HHR was, I think, $14.4 million in HHR revenue or takeout, and in June of 2025 it was over 17 million. So there's been a huge growth, about 18% statewide, and that is driven by improved properties, investments in properties, and to a great extent by the expansion and completion and opening of the property down in Swan Ranch, which is pulling from Fort Collins, pulling out of Colorado. And they did almost $2.5 million of revenue in June of 2025 and 1.65 in August of 24, 2 months after they opened. So that's really what we expected, was that people in Fort Collins and the northern parts of the Denver suburbs would be pulled north rather than going up to Blackhawk. What we haven't seen as much is the growth out of Evanston, the growth coming from Utah, and that's because those properties just haven't been updated and developed yet. We do expect that there is a great potential to pull from that market, though, and that as those properties get licensed and develop, you'll begin to see more movement of revenue into the state from that corner of the state. Karen, we can go forward. There we go. The other portion of the business that we looked at was SBAGs, skill-based amusement games, which are the skill games that are in bars, restaurants, cabana clubs, hotels, etc., and VFW halls and so on. They are in every county, whereas HHR is only in the counties that have authorized parimutuel wagering. And the SBAGs, excuse me, you can see on this map on a county by county basis where the revenues are in and it's clearly driven by population, it seems. So I thought that was interesting to look at. Then we can go forward again. And that market is primarily serving your in-state market because people aren't really going to drive from South Dakota or from Utah or from Colorado to go to a bar to play a skill game. That's just, they've got bars in those places. Well, maybe not Utah, but they've got bars in those places, and it's an amusement device rather than primarily a gambling device. So the other thing we looked at was what would the iGaming potential be for Utah, or excuse me, Wyoming, and we looked at it several different ways, using existing states as benchmarks and saying, okay, what's the per capita spend? What's the spend as a percentage of state GDP? And what's the percent and how much internet access is there? And when we looked at it that way, we came up with a range of numbers, and I can't read them on that screen, but I can probably read them here. From, basically about from $93 to $138 million annually at full build out. And again, people enjoy going to casinos, enjoy having that convivial experience. But it's a way that, if you can't get to the casino and you really want to play some blackjack or play a slot machine, that you can do that online. And that was the extent of the study that I was primarily involved in, was trying to look at what your potential revenues could be. And then however you chose to tax that, apply that rate to those potential revenues, and that's where you go. So thank you for your time. Ted?
Thank you, Matt. Karen, could you move to slide 5, please? In our report, which we filed in November of 2024, we made numerous recommendations regarding the Commission's regulatory and law enforcement responsibilities. I'd like to touch on a few of those key recommendations today. Number 1, enact a state money laundering statute. Both domestic and international law enforcement and financial oversight agencies, such as the Financial Action Task Force, for example, have long recognized legalized gaming as subject to a high risk of money laundering. In fact, most casinos in the United States must comply with stringent federal AML requirements. For example, in the United States, casinos that bring in over $1 million annually in gross gaming revenue are actually defined as financial institutions and subject to the Bank Secrecy Act and the AML laundering provisions contained therein. So the takeaway really is that money laundering is a significant issue with legalized gaming. And of course, Wyoming does not yet have a criminal statute addressing money laundering. Considering the legalized gaming landscape that currently exists in Wyoming, Commission law enforcement officers require this in their toolbox to ensure that money laundering offenses that occur in or that are even related to the gaming industry are prosecutable. And further, beyond applicability to the legalized gaming sphere, money laundering statutes are useful for other crimes, such as the prosecution of large-scale drug organizations, certain white-collar crimes, and, of course, illegal gambling organizations. In our report, we stressed that enactment of a state money laundering statute with meaningful penalties for violation including for evasion of filing requirements such as structuring, should be a high priority. And I do see that a statute modeled after one in place in New Jersey was introduced in the Wyoming legislature this year. To my knowledge, it has not yet been signed into law. We reiterate that this should remain a high priority. Number two, clarify illegal gambling laws. As we know, in addition to its regulatory duties, the commission is charged with investigating illegal gambling that occurs in the state of Wyoming. During our meetings with commission law enforcement officers, we discussed the challenges that are posed by the Wyoming criminal statutes that define illegal professional gambling. Several of the investigators we spoke with advised that the lack of a statutory definition of the bona fide social relationship, which is an exemption to the law, poses challenges to investigators and prosecutors alike. And likewise, there is ambiguity in the statutory definition of the necessary element of profit. We recommend commencing a dialogue among police, prosecutors, and legislators regarding the adequacy, the clarity, and the effectiveness of the existing statutory language relating to illegal gambling offenses. Number three, revise sports wagering vending license. Wyoming law contains an unusual requirement, automatically granting a license to a sports wagering vendor if it is licensed and operating in 3 other gaming jurisdictions. Now, with all due deference to the various gaming jurisdictions throughout the United States, the rigors of their respective licensing processes and suitability inquiries vary considerably. Further, possible issues of concern may have arisen after issuances of the licenses, which are often for a term of 5 years. Such a licensing mandate is not best practices. We do not recommend that the Wyoming Gaming Commission continue with such a licensing mandate, but rather urge Wyoming to undertake a statutory amendment to have each applicant submit to the standard Wyoming Gaming Commission licensing suitability evaluation. Number 4, allow a flexible licensing timeframe. Wyoming has a law that requires a licensing decision on sports wagering applicants within 90 days of receipt of an application. There's a similar law pertains to skill-based gaming, which requires a licensing decision within the even more constraining period of 60 days. The problem with these mandatory time constraints is that sometimes a proper licensing evaluation takes longer for various reasons. We learned from staff interviews we conducted in October of 2024 that on rare occasion, conditional licenses had to be granted because the time period expired before criminal history checks were completed. So to make that clear, that means individuals held a Wyoming gaming license without verification they did not have a conviction for a disqualifying offense. Now, this is due in no fault to the commission, is sometimes there's a large volume of criminal history requests submitted for review. But honestly, the commission is between a rock and a hard place when a clock is ticking and they do not have an answer yet from the FBI as to their criminal history checks. Also, Spectrum knows from our own experience in conducting licensing suitability investigations for jurisdictions, both domestic and international, that a proper suitability investigation into multinational gaming companies with complex ownership and operations accompanied by a long list of qualifiers may likely require additional time beyond 90 days. And notably, we noticed that pari-mutuel licensing investigations, which encompass HHRs, of course, in Wyoming, do not have such time constraints. So our recommendation here is, through statutory amendments, implement an elastic process where the executive director could authorize the enlargement of a mandatory licensing timeframe upon a determination of good cause. And finally, number 5, strengthen self-exclusion compliance incentives. Through its focus on socially responsible gaming, the Wyoming Gaming Commission administers a voluntary self-exclusion program through which individuals may choose to self-exclude themselves from any or all forms of legalized gaming in Wyoming. And it's for a set number of years or even for their lifetime. They have a choice. Self-exclusion programs are best practices in the gaming industry, having been established as a supportive tool to assist individuals who seek to make a personal commitment to control their gambling problems. They're a critical component of any successful, responsible gaming program. We observed that Wyoming does not specifically provide for forfeiture of any winnings obtained should a self-excluded person engage in legalized gaming after they place themselves on a self-exclusion list. To further deter problem gamblers, many leading gaming jurisdictions have codified such a forfeiture provision designed to disincentivize further gambling, and for that reason, we recommend Wyoming consider such a provision. In addition, self-excluded persons who nonetheless gamble should not be permitted to recover any losses during unauthorized gambling sessions. And adding such forfeiture provisions would align with best practices in the industry. Thank you for your attention. At this point, we would welcome any questions you may have.
Thank you for your time today, gentlemen. Does the committee have any questions? I have one for you. What would you say is an average time frame for a criminal background check when speaking with the FBI at this time?
Well, I can certainly address that. I would say if there was no rush to get it done and no volume, certainly could be accomplished within 90 days. The problem is when you have a multitude of applicants, not only from Wyoming, but from other states as well, that's when you can get it back.
Thank you for that. One follow-up question on a different topic might be, as I read through your report, I noticed that there wasn't a lot of mention of the Indians or the Native Americans, excuse me, in Wyoming and their casinos on the reservations. Was that taken into consideration while drafting this report?
It certainly and absolutely was. However, our mandate was from the Gaming Commission, which does not regulate or control the tribal properties. That's what I can tell you. But I stayed 2 nights at I stayed at Shoshone Rose and can't think of the other one. But I did when I was out touring the state, I did make trips to the tribal casinos, at least 2 of the 3 tribal casinos, and I did stay overnight there to understand what their operation looked like, what their hotels looked like, what their food and beverage offerings were, and where they were relative to the population centers in the state and how additional gaming might impact them. But it was not part of our scope, but it was considered.
Thank you for that explanation. I'd like to welcome Senator McEwen. He's joined us, just for the record. Any other questions? Representative Webb?
Thank you, Madam Chairman. My question has to do with the tribes. If a tribe was to purchase land, private land, for instance, here in Evanston or anywhere else, in your study, have you been able to determine, would they be able to have a full-fledged gambling casino on that private land? And let's extend that a little bit further too and find out or ask if they would be able to have, if they were to lease state land, if they would be able to put a casino on there.
Those questions involve the National Indian Gaming Commission and the Department of Interior. Typically, should an Indian tribe purchase land, that land is treated like commercial property. I mean, it's like they went out and bought a hotel, went out and bought a car wash, and that land is treated as commercial, as regular old private property. In order to convert it into trust land, it needs to go through a process with the federal government. The subject tribe needs to establish that their hereditary lands, their Aboriginal territories, extend into that portion of the state. And then there needs to be a process whereby the Department of Interior evaluates the assessment and says yes or no. Yes, those are legitimate Aboriginal lands. Yes, you used to have territory here, and we can move that into trust for you. But an Indian tribe can't just buy land and put up a casino on, buying commercial land. It has to go through the process of being moved into trust and be held in trust by the federal government for that entity.
Thank you. No further comment.
Co-chair Kolb.
Thank you, Chairman. Just to be clear, the Indian nation has defined boundaries, right? So they just can't purchase land and call it Indian territory. So it has to go through a rigorous process, which restricts that from happening. And I think that the reason why we haven't heard anything from the Spectrum Gaming Report is because the Indian nation is sovereign. So they have a right to do what they're doing on their lands, regardless of what the state of Wyoming, I think, really thinks. So it's a whole separate question that we don't have any authority over when it comes to the gaming, whether we liking it or not, whatever be the case. They're a separate nation. So I think that's why it's not. Maybe the Spectrum Gaming folks can.
Senator, that's exactly the case, Senator.
Yeah, so I think that's the reason why we're at where we're at. So we're just trying to work on what Wyoming can do. And I realize this is a huge, broad subject. And I think the question is a good question. It's certainly valid for people is why, what could happen. But the Spectrum Gaming Report really was tasked with a certain function. And so that's what we got. I think the problem gaming aspect of the Spectrum Gaming Report with gambling is not giving us a lot, frankly, because we're taking away people's personal liberties when we say, you have a gambling addiction problem, and it's basically a free will issue, and of people's ability to do good things or things maybe that I don't think are so good. So trying to change that, through self-regulation, I think is problematic, and we're not there yet trying to talk about that, because that's a whole nother subject about what we're doing about addictive gaming. We had testimony in the last meeting that, we're throwing money at it, whether it's doing any good or not. I think that's that's certainly, I think, what needs to have some discussion, because I don't see the good we're getting. There's certainly no empirical data that says that what we're doing is really doing anything. So but that's one of many things that are, certainly worthy to talk about and in the future deal with. So I just wanted to throw that in there as I think a point of view and a perspective. And if there's anybody, this chairman, that wants to, elaborate on this, I'm sure sounds like a good subject to have a conversation further about. So thank you for the chance to comment.
Thank you, Co-Chairman. I do have one additional question for you about iGaming. Would it be a fair statement to say that iGaming is legalizing Class 3 gaming with no economic benefits to the state?
Not necessarily so. You can tax it, and so you'll get tax revenue from that. Number one. Number two, in many jurisdictions where they do have iGaming, they have legalized live dealer gaming. So you have live dealers with cameras on them playing the games. Then you've got the servers that need to be in the state. You've got the technicians that need to be in the state. So there is employment, but to your point, there aren't cocktail servers, there aren't people vacuuming the floor, there aren't valet parkers. All of those kinds of jobs do not exist with iGaming, but there are jobs that do exist and do come from it. And of course, tax revenue.
Thank you for that answer. Are there any further questions for the gentleman from Spectrum Gaming? Thank you for your time today, gentlemen. We appreciate your report back to the committee.
Thank you very much. Great to be with you. Have a good afternoon.
We'll now open the time up for public comment on the Spectrum Gaming report. We do ask for a few housekeeping items, that there are decorum while you are presenting to the committee, both from the committee and to the public to the committee. And we also want to recognize Representative Worf, who is in the house today. Is there any public comment on the Spectrum Gaming report? Good morning. Thank you for joining us. Please state your name for the record.
There we go. My name is Travis McNevin here on behalf of Northern Arapaho Business Council. Certainly appreciate the committee and the report that was given. Have a few comments with respect to that, and appreciate the committee's time. If I may, Chair. The Northern Arapaho Tribe has reviewed the Wyoming gaming expansion study prepared by Spectrum, and as stakeholders in the industry and citizens of the state of Wyoming, the Northern Arapaho Tribe certainly is and has been involved with gaming for the last number of years. It is encouraging to know that there was consideration of coming to the properties and the hotels and such of the study. But as far as I understand, and from the tribal, there wasn't any outreach as far as how the casinos operate or the revenues or the impacts that were done with the study. As gaming has expanded to Wyoming, there's been a significant impact on the tribe's gaming operation. And those things are certainly underreported or to somewhat ignored within the report, and also certainly appreciate the observation that Senator Culp had that wasn't really within the purview of the study or the direction as well. Also appreciate and understand that, the sovereignty issues that were raised, but with that said, there's still impacts. And so what happens within the state and within the expansion of gaming and the different types of games that have happened in the state, while there is a certain difference in sovereignty and jurisdiction, they still certainly largely impact what's going on there within the state or within the tribal government and their casinos there. The report stated that potential casino gross gaming revenue in Wyoming is available to capture by the HHRs located at the off-track betting sites. This conclusion took into account the tribe's inconvenient, in parentheses, location and the restricted hours of table gamings, which are kind of inaccurate in scope and nature. And we would certainly invite any of the committee to come and to visit, or any additional follow-up from the Spectrum group if that would be there, if that would like to be the case. The report stated that they do not believe that future expansion of HHR in Wyoming would negatively impact the state's tribal casinos. However, since the introduction of HHR, the foot traffic, for example, at the properties is down roughly 66%. Of course, less foot traffic is less play and less revenue. The trend of disregarding the impact on tribal casinos continued within the iGaming section of the report. Spectrum concluded that iGaming would not cause an erosion of tribal gaming or even HHR, but it could restrict the growth. Looking at their own study and running the analysis there, it was forecasted the impact of tribal gaming would be decreased about another 11.2% with iGaming, and also have a significant impact on HHR should iGaming move forward within the state. This in turn would decrease revenues in non-gaming departments within the tribal casinos and additional loss of jobs. The Northern Arapaho Tribe certainly does agree and appreciates other areas of the study that we certainly believe are worth mentioning, including ensuring parties such as ensuring parity between the industries, incorporating more stringent licensing standards, effective implementation of the KYC program or Know Your Customer program, as that certainly has a large impact on money laundering and at-risk programs for financial institutions. Of course, gaming entities are certainly viewed in that light as a financial institution, so that KYC program standard is important. And the integrating a central monitoring system for regulatory monitoring and verification, all of those things contained within the report certainly appreciate and acknowledge would be moving in the right direction for the state. And again, in conclusion, the tribe would Northern Ireland, would certainly like to invite this committee, any members that at time to come visit the Wind River Hotel and Casino and allow an opportunity to show the classroom gaming, the controls, the regulations and whatnot that goes on there, so the committee could have a greater understanding of what that looks like as they do operate under the IGRA or the Indian Gaming Regulatory Act. And with that, Chair, certainly take any questions that the committee may have.
Thank you, Mr. McNiven, for your comments today. Are there any questions for him? Seeing none, I do have one for you. You talk about the economic impacts that it's had at the casino. Could you talk about, do you have a number for the job loss or for what that is meant for lack of infrastructure within the tribal lands?
Thank you, Chair. Yes, I do have a couple of other additional points here that I could share. It was previously mentioned foot traffic is down 66%. And for the committee's information, this is with a baseline of 2012. So where things were at in 2020 or 2012 to now, as it's been since that time frame that we've really seen the large growth in gaming within the state. And so that foot traffic down about 66%. In my notes, gaming revenue down 34%. And the jobs are about 500 less jobs. Of course, that is with the casino, the accompanying hotel, restaurant, et cetera, all those support jobs that coincide with that. So about a loss of, about 500 jobs from 2012 until now, Chair.
Thank you. Any other questions? Senator Cole.
Yeah, thank you. Travis, have you done any analysis on the impact specifically of online gaming? Instead of saying in a very broad sense that, everything's down and it's less foot traffic and less folks employed, to see if just how the online gaming portion, because I kind of wonder, because it does mimic a lot of what you do on a casino on a reservation, that it may have more of an impact than, say, some of these other gaming venues that we're talking about, like HHR. If you have anything, could you talk about it? If not, maybe we could get some data on it if you could find it. Thank you.
Yes, Mr. Chairman. I do not have some specifics at my fingertips here for you at this time. I'll certainly inquire on that. But you are right. The ability to iGame, to do casino-based games on your phone anywhere, anytime, 24/7 in any corner of the state would certainly be a very direct in a competitive nature to those same games where somebody would drive to a brick and mortar and play. And so your intuition is spot on that it certainly would have a significant impact. To what extent, though, I couldn't say just here today.
Thank you. Any follow-up?
No.
Thank you for your testimony today.
Thank you.
Any further public comment on the Spectrum Gaming report? Seeing none, we will. Senator Cole.
There's one.
Co-chair Cole.
Yeah. Thank you, Chairman. Just specifically about the money laundering. I think we did have a bill. I think that's kind of already went through the Senate. It died in the House for whatever reason. Could have been a lot of reasons, but we do have a money laundering bill that I think addresses that main concern as so far as I understand it. Maybe Nick with the Gaming Commission could maybe shed more light on this. But I think we have something already kind of going with. I think it's Senator Nethercott's bill that died. And it's certainly, I think it's low-hanging fruit that can move forward. And I think it helps that we've got a mix here between House and Senate of representatives that can better understand this bill and maybe speak about it, when it comes over to your side again. But we do have something, I think, that works, that did work. Maybe it needs to be tweaked. I don't know. We have the bandwidth right now. It's certainly not a top priority, but it's certainly an issue that needs to be dealt with because we are exposed to that kind of fraud. I think that, yeah, that bill goes a long way to address it, at least as a first step.
And Mr. Chairman,
Yeah.
if I might, LSO Tamara Revley, that's exactly right. We had that bill and that bill has come back to you. That was the basis of the bill draft that we have available for your consideration tomorrow at the 10:15 time, should you wish to consider it. We also have other states' anti-money laundering laws and a fact sheet on them and a printout of Virginia's law, I believe, in your meeting handout packet and online.
Thank you, Mr. Chair. Nick Laramendi, Executive Director of the Wyoming Game Commission. I was just going to mirror exactly what Ms. Tamara said. We have that in the packet for tomorrow to discuss the money laundering stuff at length. So, but I could answer any questions if you'd like.
Yeah, Mr. Chairman, I was mentioning it because it was part of the Spectrum report and about the need. That was really where it was coming from. And appreciate the LSO's work on having something to talk about tomorrow because it is important. That I was just bringing it up because of the Spectrum report, and it was included in the Spectrum report. And just if you thought what you thought about the analysis in the Spectrum report is really was my question for you, Nick. What's your 2 cents on it? Just to give people time to think about tomorrow. For tomorrow.
Thank you, Chairman Kolb. Yeah, I agree wholeheartedly with the findings in the Spectrum report. It is difficult, without having a state money laundering statute. If we were to come across that in any sort of our investigations, we would have to rely on federal partners and their willingness to pursue any sort of federal money laundering. Truth be told, unless it's, wrapped up big with a nice bow on it and it's extravagant, they won't touch it. So it would be definitely helpful.
Follow up?
Thank checks, as pointed out with the Spectrum report. What would you like to see for time? I mean, if you are pressed for time and have to approve applications before you get information back, what are your thoughts on that for timing?
Thank you, Chairman Kolb. That's a difficult question as well. Like as noted, we've only run into it just a couple of times. To answer Representative Lean's question, the way that we process the backgrounds is we get 2 sets of fingerprint cards. Those fingerprint cards get sent to DCI. DCI processes one of the cards. They send the other card to the federal government for the FBI to process. During for example, our live racing season, we will send DCI hundreds and hundreds of fingerprint cards a week for them to process. So if we have, say, 200 new license holders for the racetrack, and we've got 3 or 4 skill game applicants at the same time, they're all mixed together. So we're sending, 200 plus cards in a week, and all the other agencies and licensing boards across the state are sending them to the same 4 people at DCI for them to process. Sometimes we can get backgrounds within 21 to 30 days. We have had times where DCI is so backlogged that it's taken 90, 120 days. So the recommendation that they have with the flexibility, I think, is probably the best way to do it, to where it's not extended out for any unnecessary amount of time, and we keep it as tight to the 60 and 90 days as possible. We try our best to absolutely meet those deadlines and process things as quickly as we can. Sports wagering is a difficult one. Some of those, they're pretty in-depth ownership structures and everything else. On the skill game side, a lot of it, we're talking mom and pop bars that are owned by a couple, and those ones are fairly simple, but some of the other ones definitely get pretty in-depth.
Thank you for that. Do you have a follow-up, Co-Chair Kolb?
Yeah, thank you, Chairman. And just a broad question, Nick, and maybe I'm kind of all wet on this thought, but can you all issue licenses contingent? I mean, are they issued contingent upon approval of background checks? I mean, is that part of how you do it?
Senator Kolb, we have done that before to where we've run up on the deadline. So we've issued a conditional license that, this license is in effect while we wait for the background. Or if the background, as long as the background comes back clear, then it just rolls over into a standard license. But if we have a hiccup, then we would have to reconsider that license.
I'll take a follow-up on that question. Have you come into a situation where you've had to try to figure out how to balance that, where a background check has come out not as clean as it was expected to?
Madam Chair, no, luckily we have not had that happen. We've not had it happen to where we've had to end up, withdrawing or rescinding a license that we've issued conditionally because of that.
Any further questions for the director? Thank you for that. Please don't go too far. You're up next. Any other further comments on the Spectrum Gaming report? And I would like to recognize Senator Schuler. I apologize. I didn't see you there when I recognized Representative Worf. We'll go ahead and close public comment and we'll move on through our agenda. Next would be parimutuel wagering, historic horse racing, and local control with local precedent. We'll start with an overview from LSO.
Members of the committee, I'm Tamara Reveley, and I work with LSO. I'm the Legislative Counsel. I worked on the Joint Appropriations Committee last year and many years before that, and sort of inherited this committee when it moved on to take over gaming this year. And what was requested for this was a little bit of an overview on the legal precedent for parimutuel wagering. And so I did put together a quick memo. Now, it's a high-level overview of the legal history related to off-track betting, to simulcasting, and historic horse racing. So the memo doesn't touch on any other issues with gaming or any other criminal issues, skill-based amusement games, or any other types of gaming. And I looked at it since the beginning. There's been about 4 decades in which historic horse racing, what is now historic horse racing, in which simulcasting has evolved. It was first legalized by the legislature in 1987, and the legislation that was passed authorized broadcasting televised races. The legislation didn't specify that the races had to be live, but I imagine they were all live at the time. They probably had old boxy TVs that were broadcasting these races, and where individuals could place wagers off track. At that time, the 100-mile proximity rule was enacted. That's been in the statute for simulcasting since the beginning for Wyoming, as well as the county approval requirement. Now, over the past 4 decades, there's been kind of a back and forth with legislative action, agency rules, attorney general guidance, helping interpret statute, then litigation and judicial rulings, and kind of some back and forth. And so rather than just focus on the litigation, in your memo, it's dated July 28th, 2025. It's addressed to Co-Chairman Lean. And its subject is the legal history of simulcasting OTB and HHR. I do bring in the legislative history, or at least through 2013, the legislative history of simulcasting and historic horse racing. So you can kind of see all that back and forth together, as well as a description of some rules and legal cases and their outcomes. So 1987 is where we were at. It was legalized 1991. Legislature acts again to allow only permit applicants who are authorized to conduct live events. 2001, legislature comes back, tries to expand simulcasting to dog races. 2003, after several failed attempts and vetoes in 2001, it was expanded to dog races. Then in 2003, the Parimutuel Commission at that time amended their agency rules that they had promulgated some years prior. Those rules revised the definition of parimutuel event to no longer have live, and that allowed for them to permit historic events. Now, statute was silent on whether they needed to be live or historic, so it was a reasonable interpretation that that in the first place they put live in the definition in their rules, and then in 2003 they took it out. Those rules were properly promulgated. They were reviewed by the legislature's management council and LSO and signed by the governor, and they were in effect until the 2005 court decision in which Laramie County approved and permitted some HHR machines. So these are, it's now simulcasting, and off-track betting is now morphing into historic horse racing terminals. And so that terminology, I'm going to try to keep it consistent, but simulcasting, which includes now HHR since it was permitted and allowed in the 2003 rule change. It's happening over the state. It's in Laramie County, and Cheyenne ordered the machines removed. So these are probably illegal gaming devices, gambling devices, which are illegal under the Wyoming Criminal Code. So at the time, Wyoming Downs Rodeo Events LLC sued. The district court determined that the terminals were in fact illegal gaming devices and that the commission had exceeded their authority by granting or permitting those HHR terminals. It was appealed and the Supreme Court agreed with the district court. That's 2006. So 2006, HHR becomes illegal. It's considered an illegal gaming device. And from 2006 to 2012, the legislature may have considered various bills to go ahead and legalize, but they didn't have anything passed until 2013. They did make some policy changes related to the takeout and live racing requirements, some statutes for out-of-state facilities that are simulcasting where Wyoming residents are betting on those out-of-state, and some other policy changes. It's not until 2013 when the legislature allows HHR. They pass the legislation to specifically address those parts of statute that the courts had taken issue with, that found that because those statutes existed, because illegal gambling device was defined the way it was, it prohibited terminals. So the legislature passed the legislation to narrowly add in historic into the definitions and to make sure it's not a crime, but the terminals were exempted from illegal gaming devices. Then we move on to 2014, and I will not pretend to be an expert on any of these cases where there's probably people in this room who were plaintiffs or defendants or involved in the cases. I'll just summarize them, but I'm sure they can add much more color and context to them. 2014, Sweetwater County denies Wyoming Downs off-track betting or their historic horse racing permit, because of course the county must approve off-track betting or simulcasting off the permitted premises. The district court reviews the county's action and finds that their denial was arbitrary, capricious under the Administrative Procedures Act. It violated Wyoming's equal protection provisions in the Wyoming Constitution, and that the commission exceeded statutory authority. That stood. And in 2015, there are some other events that happen that result in Attorney General interpretation of existing statute. For one, the 100-mile rule, and it might have happened before this, but the opinion that was made public was in 2015. The Attorney General looked at the rules and statute and determined that that 100-mile rule only applies to the time during live events, not year-round. Because permitted premises, your permit is only good for the time and duration of the actual live event. So a permit, by its nature, the premises are only permitted for that time. So it's not year-round. They also confirmed that bonus rounds of some games were not meeting the elements of parimutuel wagering for some of the machines that had some bonus rounds to play on that was randomized and it didn't qualify as parimutuel wagering. Then we move on to 2022. This is after Campbell County passed a resolution to revoke prior approval for Wyoming horse racing and Wyoming Downs for their off-track betting or their historic horse racing. The district court found that counties lacked authority to revoke. Very simply on its face, the statute said counties, you have authority to approve permitting or permitted simulcasting off the permitted premises. It said nothing about revoking, and the court didn't find that there was any inherent authority. That was appealed, and the Wyoming Supreme Court agreed. There's no authority to revoke approval. So my memo provides a little brief, kind of high level, not very technical summaries of just this history. And I'm sure there's, many people in this room who can answer a lot of questions about this history as well.
Thank you for putting together this packet and making sure that we have a understanding of the legal aspects of local control within our state right now. Any questions? Co-Chair Cole.
Yeah, thank you, Chairman. Tamara, so I guess what I really heard through your analysis is the reason why I had to re-sign a document as a county commissioner under protest when I was told that I was arbitrary and capricious. Really, the crux of it is we didn't have the clearly written authority to deny. That's really what the courts have said. I mean, according to your analysis. So at the very least, we need to add that into the language. If that's what the Supreme Court has said, then that seems to be a pretty simple off-ramp, at least for one way of handling that. What's your thoughts on that?
Yeah, let me follow up on that and clarify a little bit. In the most recent case, the Supreme Court said there is no authority to revoke. When the law says you may approve, that's it. You may approve. No inherent authority to take that back. No take backsies. That's what they said. With the power to deny in the first place, statute just says you have the power to approve. They don't say what grounds you can deny on. You don't like the business. You have too many businesses. Whatever the reasons are, statute is completely silent on when a county can deny its approval. And so it's just held to the standards that are somewhat inherent, either the Administrative Procedures Act, which allows for a review of agency actions, and counties are agencies for which their action can be reviewed. And so let me just restate that distinction. The Supreme Court said no authority to revoke. The district court in that case said, if you're going to deny, you have to do it for a legitimate public reason. And under equal protection, under the Administrative Procedures Act, deciding to protect, because what was on the record was that the interest of the live track was being protected. And that's why the permit to simulcast was denied. And the district court said that's arbitrary and capricious. Just because you want to protect live racing industry and that particular operator, you can't deny on that basis, especially when you're allowing other operators to simulcast. It's not that you're objecting to simulcasting, it's that you're objecting to this competitor entering the market. But I think your question was, could statute address that? Yes, statute could be more clear in why a county can deny and set that out and set out the standards so they don't have to be litigated.
Follow up.
Thank you. And I can give you the background is that as a commissioner, we believe that we had the authority to approve, we would have the authority to deny. Now, clearly, that's not what the court has said. So now the new day is no, not without statute clearly stating you have that authority, you can't take it. I mean, that seems to be where we're at today. What's your thoughts? Thank you.
Yeah, as of right now, the judiciary has weighed in. If counties need the approval and the legislature decides they should have the approval to revoke, then we'll need to do that by statute change.
Follow up. Any other questions? Senator McEwen.
I'm just curious, Madam Chairman. Just curious, you said it could be denied for a legitimate reason. Can you give me an example of what a legitimate reason would be? It seems like we really don't have the ability to do anything. So if you could help me with that, I'd greatly appreciate it.
Well, I can speculate where it hasn't been litigated to my knowledge and defined by a court. Generally, counties in the state has police power, which means you have the power to regulate the good of the public. And with that police power, if the county found that there was some public externalities that were occurring because there was too much betting, that there was a lot of police calls, that the good of the public was being hurt. There was crime. There was something bad happening. And to protect the public, I think that would be a legitimate reason for the county to deny. If they made findings saying, you know, for these reasons, there's market's oversaturated, or we've exceeded our availability of police force, or some other issue, the safety of the public is in danger. I think that would be a legitimate reason. What this reason in particular, the record showed, was that it was economic protectionism, and the district court had to look to a lot of other states to say that's not a legitimate reason. But it's usually a pretty low standard to have a rational basis to pass laws or to act as a county governing authority. Follow up.
Thank you.
Thank you for that. Any other questions? I do have one question for you regarding the 100-mile rule. Is there rules written by the Wyoming Gaming Commission that gives them the authority to work together to not be paying each other out?
Thank you, Madam Chairman. I do think I'll let the Gaming Commission answer the specifics of that. Statute simply says that the 100-mile rule applies unless waived by the Gaming Commission. And so when the Gaming Commission is going to waive that, has all been done through administrative interpretation of that statute and their agency rules.
Thank you. Seeing no further questions, could we bring
Madam
up
Chairman?
Director Laramendi? Representative Johnson.
Just one question for Tamara. Thank you, Madam Chairman. The county commissioners can allow gaming in their respective counties. Wouldn't it be better to have them zone those positions and not actually approve a license? I mean, that would, as long as you met all the requirements for the zoning requirement, you could open up your business. Is that a fair statement? Is that?
Representative, I do think we have representatives from the county here, and I can have them talk about how it works in Wyoming counties. But statute is really fairly simple, and simply saying that to have HHR to conduct parimutuel wagering off the permitted premises, you must have county approval. And then, of course, you must have had the voter approval to have parimutuel wagering in the first place. And, you know, that's all that is said. Now, with Wyoming zoning laws, they don't go into the details of what a county or a municipality can zone related to gaming. There's no specific direction on how they should zone or whether they should have districts. So whether they decide to, or what is the best policy there, I think the counties can talk about how much their authority, how much it currently exists, and how much they would like to see it changed, if at all.
I would just ask.
Follow up, Representative Johnson.
Yeah, thank you, Chairman. I would just like to state that the games of skill are already zoned through the, if they're in local bars or truck stops or whatever. Why wouldn't that be a way to enhance the gaming in the state of Wyoming? I mean, it would not take away local control, but it would give everybody a fair chance to say, I just want to put my business here. It meets all the zoning requirements, and please issue the license. Thank you.
See if I may follow up.
Yes, please do.
That's an excellent point in comparison. With the skill-based amusement games, the Wyoming legislature, after a couple years of back and forth and working the policy, made the decision to limit those to certain establishments, to truck stops, other establishments that sell beverages, that sell alcoholic beverages, etc. And they also put in place a number limit of how many could be in that establishment. So that's state policy. Then whether the local government allows for a bar to be, in a residential neighborhood, or whether they allow it to be in a residential district, that affects where bars are, which the state has said through legislation where there can be up to 4 skill-based amusement games. And there certainly could be a similar policy of capping or requiring them to be in a certain establishment as accessory use.
Any follow-up? Thank you for your answers there. Any further questions for Ms. Raveley? We'll continue on to Mr. Director Laramendi.
Thank you, Madam Chair. To answer your question on the waiver for the 100-mile rule, commission rule basically just mirrors state statute that says that in order to waive the 100-mile rule, the commission requires a written agreement between the operators. That's all it says. It doesn't mandate anything about what the agreement has to contain. It doesn't specify any sort of grounds to the agreement. It's whatever those businesses decide to agree upon. That's what the commission considers.
Thank you for the answer to that question. Co-Chair Colt.
As I draw my pen, thank you. But just to be clear about this, the Wyoming Gaming Commission has set these rules themselves. You guys made up that rule that said if we have an agreement amongst folks that we can waive the 100-mile rule. That's not in statute. The statute clearly gives you the authority to do something differently than that if you wanted to. I guess so the big question is, do you really think it's the best solution for what we're talking about now with the 100-mile rule to give you flexibility besides this agreement between operators? I mean, what are your thoughts on that, Director?
Thank you, Chairman Cole. State statute is actually what says that we can waive the 100-mile with an agreement, and commission rule just mirrors the state statute. So state statute says that the 100-mile exists for simulcasting, and it says that the commission can waive the 100-mile rule upon agreement between the operators. That's what the state law says. So the commission just mirrored that in their rule.
Follow-up?
Yeah, just thanks for the clarification. It sounded like it wasn't like that, but thank you for clarifying that.
Thank you. Please proceed with any presentation that you have for us.
Thank you, Madam Chair. Going along the topic of the local control, kind of the current status, I submitted this all to you, but I'll briefly go over it. Wyoming statute requires that an operators receive county approval prior to offering simulcasting within the county. It's important to remember that before they can even offer it in the county, it has to be put to the voters. As it stands today, there's 7 counties in the state of Wyoming that do not allow pari-mutuel wagering. I couldn't name them off the top of my head, but there's a few of them. So as it stands today, when an operator applies for an off-track wagering location, they're required to submit the simulcast and historic horse racing application, financial statements from the previous year, photos of the proposed locations, a county resolution that grants authority by the county to operate the establishment, the floor plans of the location that shows the machine layouts, surveillance structure, secure areas. If they do not own the property, they're required to supply a copy of the leases between them and the property owners. If it's also not owned by them, the owner of the property has to complete what's called a host facility application. They fill out a host facility application, and they also submit fingerprints for background checks to ensure that the property owner themselves is not a nefarious actor. They also are required to, it's required to contain a feasibility study, which includes the expected revenues, the level of anticipated wagering activity from the location, the source and amount of revenues expected from anything other than pari-mutuel wagering. So if it's going to have a liquor license or food sales, they'll include that, food and beverage sales, estimates or estimations in there. The cost of operating the simulcast facility and the probable impact of the operations on local revenues to the government. So it'll break down how much they anticipate it'll increase the breeders award, city taxes, county taxes, state taxes, the LSRA taxes as well. Although it's not required under rule or statute, we have strongly encouraged the operators to also work with the municipalities, talk to the city councils, and get letters of support. Included in your packet, actually, I've submitted the most recent example of one that we had received from the city of Gillette. And that just kind of goes over that, you know, that's helpful for the commission when they're reviewing these applications to see that these operators are not just working with the counties and skirting the city, but they're working together, and the city is well informed of what the operator is planning to do. I know in years past, I've received phone calls from municipalities saying like, what happened? Like this OTB just showed up out of nowhere, because the city and the counties don't always talk very well. So it's been very helpful to have the operators work with the cities and the counties, even though they're not required by law or rule to work with the cities. After we receive the application, the commission reviews the application in its entirety. We look at, especially now with the gaming study, we have, you know, numbers that we can look at for saturation levels, estimated wagering activities, population bases. Most of the locations that we already have existing locations, so we can see historic trends of wagering to see what is going on in that county. We present all of that stuff, or we compile all that stuff into a lengthy report, and then it's presented to the commission as a whole for their consideration. Under commission rule, the commission is required to review a few things prior to approval. They're supposed to assure the applicant's general benefit to the state of Wyoming, the applicant's general benefit to the state of Wyoming's horse racing industry, the applicant's integrity, their individual and corporate conduct, their criminal history, their betting and gaming industry conduct, their credibility, their experience and expertise in the racing industry, and their financial stability. And I would stand for any questions on the application process, if there are any.
Any questions for the director? Co-chair Kolb.
Thank you, Chairman. Yeah, this is, let me get this turned on here. Nick, is the follow-up back to the 100-mile rule. So sorry, backtrack a little bit. Specifically, okay, because devil's always in the details about how we do this. Within the 100 miles, you have to have 100% agreement between 100% of the parties in order to waive that agreement. Or is it a percentage? Or how do you exactly do it? I mean, within 100 miles, can you lay out your procedure precisely? Because this is coming up now as a question of, you know, how are we exactly doing it? So could you, I guess, maybe verify your procedural steps on how you actually carry out this agreement and how many folks have to agree to said agreement? Thank you.
Thank you, Chairman Kolb. So I'll give you the most recent real world example. In 2022, the Wyoming Gaming Commission, there was no agreement between the current 3 licensed operators, 307 Horse Racing, Wyoming Downs, and Wyoming Horse Racing. There was no agreement whatsoever. So when 307 Horse Racing was running live races at the Camplex in Gillette, Wyoming, the commission was ensuring that every OTB within 100 miles, as a crow flies, so all of the OTBs in Gillette and the ones in Sheridan, were closed down 15 minutes prior to the first post time of the race, and then they could not reopen until the last race went official. So what they would have to shut down. They already knew what their schedule was, so they knew what 15 minutes prior to post was. And then our investigators or agents that were at the track would actually contact every manager at every location at the completion of the race day to show them that or tell them that they could reopen. That was in 2022. In 2023, 307 Horse Racing and Wyoming Horse Racing entered into an agreement. So when 307 was racing in Gillette in 2023, Wyoming Horse Racing's OTBs could remain operational because they had an agreement, but Wyoming Downs did not have an agreement with 307. So Wyoming Downs locations had to shut down. So during 2023, if you went to Gillette, you would see the Derby clubs, 307's locations were open. the Horse Palaces, Wyoming Horse Racing's locations were open, but the Wyoming Downs locations were closed because they did not have an agreement. So the agreement has to be between the live track operator and then whichever operators have OTBs within 100 miles. So if they have an agreement with one, that one is allowed to operate. If they don't have an agreement with the other, then that one is not allowed to operate.
Thank you for that. Further questions for the director?
Chairman Lean, Steve here.
Representative Johnson.
Yeah, I just want to make clear that this 100-mile rule is an attempt to increase the purse sizes for the tracks racing in that county or that area. Is that correct? I mean, the intent of this law was to improve the purse size and improve the athletic ability of the horses and the jockeys and improve horse racing in the state of Wyoming. Is that not correct? Am I? And I don't understand why if we are allowing these gaming facilities to use off-track betting for wagering, the intent is to increase the purses for the horse racing. It's not to raise taxes or make money for other corporations. The intent is to increase the product of horse racing. Is that correct?
Director?
Thank you, Madam Chair. Representative Johnson. So I was not around in 1987 when this law was passed, so it's tough to speak to the actual intent. But what I have learned in the research that I've done, the true intent of the 100-mile rule was to encourage attendance at live horse tracks. In 1987, well, if you go look back in, say, 2001, OTB operations were completely different than what they are today. You would go into an OTB and it would be a bank of television screens showing live horse races and live horse races only. And you would walk up to a teller or a machine and wager on a live horse race. So with the 100-mile rule, they were trying to encourage people that were within 100 miles of a live racetrack, instead of wagering on a live horse race on a TV, to actually go to a live horse race track and wager at a live track, a local live track. So that is the way that I understand the intent of the 100-mile rule back in the late 80s and early 90s. That's what the intent was.
Follow-up, Representative Johnson?
But now that we have these, I'm just going to say slot machine that mimic horse racing, we have allowed these machines to come into our communities, and I believe the intent there is to increase the value of the purses in those live horse racing events. I know that in 1986 we didn't have all of these facilities. We didn't have the slot machines, off-track betting machines, and I believe that if we are going to increase the attendance at live horse racing or make Wyoming a horse racing state, we need to do these things to improve the purses at each of these events, and not just allow a loophole to allow people to have betting facilities that have no benefit to the state of Wyoming other than to raise tax revenues. And I'll let it stand at that.
Do you have remarks for that, Director?
Madam Chair, if I may, Representative Johnson. So in 2012, the passage of the HHR was to re-incentivize the live horse racing. There was actually an article written just a day or two ago in the Pollock Report, which is a large horse racing publication that talks about Wyoming horse racing, just as an example. Wyoming's horse racing purses this year are up 40% from last year. That is strictly due to the opening of the Swan Ranch property in Cheyenne. They've increased their purses, a 40% increase in their purses this year from the operation of that one OTB. So each operator's OTBs do support their own individual tracks. So any derby club that you go into, that money is going to fund purses and operations at the Camplex. If you're here in Evanston and you're going out to Wyoming Downs Racetrack, any OTB that you go to that's operated by Wyoming Downs, it's funding that racetrack. And then all of the Horse Palace locations are funding the race meet in Sweetwater County at the Sweetwater Events Complex. So that's where the HHR is supporting those live tracks. I didn't submit it this time. I think I submitted it last time. The increase in purse numbers over the last just 10 years after the implementation of HHR, it was up like 1,300%. In the last 10 years, purses have gone up 1,300%. I know last year at Wyoming Downs, we were running overnights that were about $5,000 to $6,000 overnight purses. And now I think the lowest purse that I've seen in the condition book's 13,000. So they've almost doubled. So the purses have definitely gone up as a result of the HHR.
Yes.
Thank you for that, Director. Representative Webb, do you still have a question?
Thank you, Madam Chairman. I want to go back to the licensing and site selection just a little bit, okay? And it's because I don't know. And I need to get this clear in my head. Why do the counties have what I'm going to call precedence over site selection over the municipalities, even though the establishment may be put in the confines of the city limits?
Madam Chair, Representative Webb, that's a policy question. That's what was written in the law. That's the best answer that I can give you. State law just says that they're required to have county approval. It says nothing about municipal or town approval.
Follow up?
So nothing, no history that you're aware of then as to why legislatively that was.
Madam Chair, Representative Webb, I have no knowledge of any history.
Thank you.
Further questions? Co-Chair Cole.
Thank you, Chairman. Just to help out everybody with the history of the 100-mile rule as a county commission perspective goes, it wasn't really what you were, I mean, it does do that. However, the county commission back in the day, back when, before it was arbitrary and capricious, was very much concerned about the tracks failing. This is what people don't know because, of course, it's history, and I guess it shows you maybe how long I've been around. But back in the day, the tracks failed, and there was no live horse racing, and it got reintroduced in where? Sweetwater County brought it back, working with the folks in Evanston. Matter of fact, Eugene Joyce is in the audience, was part and parcel with that back in the day. And we were very much concerned about the tracks failing and then losing live horse racing. So yeah, it was put in there to keep live horse racing alive and to promote the industry, right? And at the end of the day, if the tracks were too close together, you wouldn't have enough folks going to the tracks to support the track in a live horse racing event before we had all these other ways of making the purses larger. It was a way of protecting the live horse racing industry, and it was a fledgling industry. And it's not that way anymore. You know, things have changed dramatically from those days to now. And we face a new set of problems. But the reason in my mind was to protect live horse racing, and to protect it by what? Not destroying it like what happened between Evanston and Rock Springs and losing the industry. And that's really the history on, at least in the 2010 perspective, on how things developed. And that was the thought, certainly in I can tell you the Board of County Commissioners' mind in Sweetwater County, that we wanted to help the industry. So that's my 2 cents on what happened in the past. And we're not there anymore, where it's a new day. So it's certainly a good question, though, about the 100-mile rule and why we need it, or why maybe we don't need it. But certainly a debate topic that we're going to yet talk about. But I guess you have any thoughts about that, Nick? You know, what you know about it, or maybe your history doesn't go back that many years, but just your thoughts. Thank you, Mr. Chairman.
Thank you, Director.
Chairman Cole, to your point, that's exactly what it is. In fact, in the documents that I had submitted to you, you'll see that Wyoming Downs, you know, they started in the 1980s. They operated as a live horse rack until 1998. And And then from 98 to 2006, it operated under its second owner. But that track was ultimately closed from 2009 to 2013. For 4 years, that track sat dormant because there was no way to fund it. It wasn't working. And that track is now, I'm sure there's somebody in the audience that can tell you what the current numbers are this year. But this year, the amount of participation that is at that racetrack is unbelievable. The commission had to request the operator to hire an additional outrider just because of the amount of horse participation that they have at that track this year. It's incredible. And their weekend people that are coming, if you go out there, just drive up on Bear River towards Bear River, the amount of campers that you'll see out there, those campers have been out there since the beginning of the season. They'll bring those campers up from Utah. They'll park those campers there, and they're here every weekend for the races. So it's incredible to see what it's done to go from nothing to what it is today. It's pretty incredible.
Thank you for that insight. I do have one question for you in that regards. Could you talk a little bit about what the track attendance is like on a day, or shall I ask that of an operator?
Madam Chair, an operator would be able to give you better insight into that than I can.
Any further questions? I have one for you, Director. I want to go back to the application process. Can we talk about applications and when they're approved? Is there a set guideline from the Gaming Commission as to if they're 1 year, 2 year, 5 year, 10 year in perpetuity? When you originally permit or are looking at an application, is there a timeline for what is uniform and available to each applicant as a set guideline?
Madam Chair, under state law, we can do up to 3 years. That's the way that it's written. We have one operator that has historically always just done a 1 year application. They reapply every year, and we go through the process every November in our fall meeting. 2 of the other operators do 3 year applications, so we revisit those every 3 years. However, on the 3 year applications, what we do is we do the date portion of live racing at the November fall meeting for the following year. So for example, right now, Wyoming horse racing was permitted for 25, 26, and 27. Their permit is good, but we only awarded their 25 dates in 24, their 26 dates in 25, and their 27 dates in 26. We don't go dates out that far just to ensure that we're looking at dates all at the same time for all the operators. But 3 years is the max that we can do, and it's really up to the operator how they choose to apply. They can do a 1 year or they can do a 3 year. I mean, they could do a 2 year if they wanted to as well, but never seen that, just a 1 or a 3.
Thank you for that. My follow-up would be just to make sure I'm very clear that the business applying for the permitting is the person deciding 1 year or 3 year.
Madam Chair, that is correct.
Thank you. Follow-up, Co-Chair Colt.
Thank you, Chairman. Yeah, and on that note about the 1 and 3 year kind of variance and permit issuance, how many do you have of 1 year compared to 3 years? I mean, you have some numbers there for us? Thank you.
Chairman Kolb, currently we have 2 1 year permits and 2 3 year permits. That's what we currently have right now. The 2 3 year permits, actually, they're running in their last year of the 3 years, so they'll reapply this coming year for what I assume to be their next 3 year permit. That's what they've always done, is 3 years.
Follow-up.
Thank you. The follow-up question. So we have folks that are going to be up for renewal. When do they renew? Let's just say a statute change happens, and that's the only time I think we can make a change with the application for renewal. You know, we can change the statute. When would that be? And if they are up for renewal, what would you say is the deadline that you have to have a statutory change, you know, in place in order to enact that rule for the renewals?
Chairman Kolb, so for the live event permits, they're always considered at our November meeting. So we actually, the operators are required to have their applications to the commission 60 days prior to that meeting. That meeting takes place towards the end of November. So around September, they're going to have their applications just in a couple of months. They'll have their renewal applications to us for either the calendar year 26 or 26, 27, and 28.
Follow up?
Madam Chair, I have a question for.
So-
Director.
Hold on a second there.
Just 1 second, Representative Johnson.
So do you anticipate a flood of people renewing for 3 years?
Senator Kolb, I anticipate that they will all do 3-year permits. Actually, I know the one that historically has done a 1 year has, since they've recently changed ownership, they didn't understand why it was always a 1 year anyway. So I believe that the new ownership structure will do a 3 year. So we will do the 3 years for the existing 3, and then the newest operator. They had originally applied for a 3 year. They were granted a 1 year just with the construction and everything that was going on. And with it being so new, the commission wasn't comfortable granting a 3 year. So they just granted a 1 year. So their 1 year, the newest operator, their 1 year actually runs through calendar year 2026. So their renewal won't happen until November of next year.
Thank you for that. Representative Johnson?
Yeah, I just have a question. What is an exotic wager on a terminal in a off-track betting situation? It says you have to have at least 2 terminals that offer each type of exotic wager. And it's kind of I don't understand what that is, and just explain that to me a little bit. Thank you.
Madam Chair, Representative Johnson, that's kind of an interesting way that they wrote it into rule. If you go further on, it says that an operator is required to have 2 terminals that offer exotic wagers. Yet it also defines that every HHR terminal in and of itself is an exotic wager. So a standard horse wager would just be like a win place or win place show. Exotic wagers are when you start getting into trifectas, superfectas, quinellas, daily doubles, to where you're picking multiple winners in multiple different races. That's what a exotic wager is. And the machines, they all operate on exotic wagers anyway, because it's multiple race cards and you're looking for multiple winners from multiple cards. None of the terminals operate like just one race. It's the minimum is 3, and you're looking for win, play, show, win, play, show, win, play, show on 3 races to hit, the super jackpot.
Follow up?
So that's a way to increase the winnings per machine, right? But I don't think did the people understand that that's, I think when they just push the button or pull the lever, they don't understand what they're betting on. Is that a fair assumption? I mean, those machines will.
Madam Chair,
those machines will pick the odds, within a second, and you just need to. You're not really sure what you're betting on.
Madam Chair, Representative Johnson, realistically, no. 99% of the people that play it assume that they're playing a slot machine. If they take the time to actually look into the information on the machine, though, it'll tell them exactly what it is, and it'll give them the ability to handicap that race or those races, just like they're at the racetrack. If you go to any OTB and you press the little help button or the little I button on one of the terminals, it'll tell you what you're looking for. It'll say pick the first, second, and third winner in the first race, pick the second horse in the third race, so on and so forth. But the vast majority of people just play it like a slot machine. They sit down, they put money in it, and they press spin. So when they do that, they're playing on post time or morning line odds, depending on the manufacturer of the terminal. A lot of them use post time odds or morning line odds. So if the player just sits there and presses the spin button, the machine or the computer is actually picking the finishing order for you based on what it was the day that race was run. So on post-time odds, it's going to put them in the order that the betting public thought that they were going to finish on the day that race was run. If it's post-time, it's done by a professional handicapper in the morning, saying that this is the running order that they think the horses are going to finish, and then it just picks them in that order for you.
Follow up, Representative Johnson?
No, thank you. I'm sorry, I didn't lower my hand. Thank you.
I do have one extra question for you. On the applications that are submitted, is there a public comment period?
Madam Chair, what we've started to do recently, when I receive an application, I put together a notice and send it to the city and county that it's coming from, and I'm encouraging them to publish that on whatever they can, on their Facebook pages, or if they have Instagram, whatever the case may be, to really try to encourage public comment. For a long time, we've never really seen a lot of public comment. I don't have access to put things for, say, Laramie County's Facebook page, but it's gotten better. We've really been encouraging public comment across the board when we're getting applications.
Thank you. One additional question would be, in the Wyoming Gaming Commission process, if there's a business name change, do those machines that are permitted under the business old name remain in effect and grandfathered in essentially to the new business name?
Madam Chair, it would just be a transfer of assets.
Thank you. Any further questions?
Oh, just.
Thank you.
Senator Cole.
Thank you, Chairman. Have you ever denied a permit issuance by public comment?
Chairman Cole, no, we have not. No, we've never actually received a public comment. Well, we've received public comment in opposition of certain locations, but not to a level that has caused a denial.
Follow up?
Yeah, thank you, Chairman. And that's because you lack statutory authority. I mean, really, at the end of the day, is that you're not the LSO, but is that your opinion?
I think that's part of it. I think the commission as a body, is worried sometimes about denying based on, or what grounds can they also deny on? It's kind of the same thing that happened in Sweetwater County. We've allowed one, so when can they say no? That would be helpful for them as well.
Thank you, Director. Any further questions from the committee? Thank you, Director. I'm going to move that we take just a 10-minute break and reconvene at 9:15 and then open with public comment for this section. 10:15, we'll come back from break. when we're live. Thank you. We'll call the meeting back to order. We'll be ready for any public comment on the section of parimutuel wagering, historic horse racing, and local control, the local precedent. Ready? Please state your name for the record and let us know your remarks.
Thank you, Madam Chair. My name is Affie Ellis. I'm an attorney with the law firm called Brownstein Hyatt Farber Schreck. Today, I'm here representing my client, Cowboy Racing. And I know we're a little behind schedule, so I'll try and keep my comments brief, but I really want to thank LSO for preparing this memo, because I think to understand some of the problems that we hear about today, the challenges we face, it's helpful to understand what's happened in the past to maybe understand all perspectives. And to that end, I want to thank Senator Kolb for his candor. I feel like I understand his concerns a lot better after listening to his commentary. But in the memo itself, you'll see the mention of that Sweetwater County case that occurred in 2014. I didn't live through that. I was not in the legislature, was not involved in any of that litigation. But if you read that district court letter, essentially our understanding of what happened was Wyoming Downs wanted to open a facility in Sweetwater County, which would have required permission from the operator in Sweetwater County, who is Wyoming Horse Racing. You heard Senator Kolb say that there was concern about the viability of the track. And so I think the narrative that was told was, if you allow this competition into our area, our sandbox, our 100 miles, that's going to prevent us, our gaming facilities, from being successful, which will then prevent the horse racing activity from being successful. And so the court, my understanding was that the approval died for a lack of motion. And so there was this litigation that ensued. But if you go back and read that opinion, I think it's pretty enlightening on some of the things that we need to be very thoughtful of. That opinion talked at length, and it's difficult to find, but at our last meeting, your last hearing, I provided it in your meeting materials. So if you go back, I believe LSO has posted all of that. If you read that decision letter, the Judge Couts, who went on to become a Wyoming Supreme Court Justice and now was appointed to serve as our Attorney General, talked very specifically about the concern of creating monopolies. The county commissioner's denial would have essentially created a monopoly for Wyoming horse racing within that 100 miles. Why does that matter? First of all, if you're a Wyoming citizen like I am, I tend to think we don't like monopolies. We believe in competition, free market competition. But beyond that, if you look at other places, and I think Las Vegas and Nevada are the most notable, there's a reason that we're worried about monopoly creation because of the elements of crime that it causes. So if you go and read the Nevada state statutes regulating gaming, they have a declaration of findings, and they repeatedly say, fair environment. We don't want to create monopolies. We don't want to create monopolies. So I think that begs the question then, this concern about economic protectionism, we heard the courts found is not a valid one. It violates the Wyoming Constitution. The court found it to be arbitrary and capricious, and there were other problems with it. But the court talked about some other things in that opinion letter too. One of them they said is, whatever you do, counties and cities, you have to do it fairly. If you're going to have zoning ordinances, they have to be applied fairly. So the questions come up, well, what would be grounds for saying no to one of these operators coming in? Well, what if, and this is an example that we've been hearing about with one of our projects. Well, one of your proposed gaming locations is really close to a school, and we're nervous about that. As my client rightfully acknowledges, we are listening to those concerns. But I think our concern is, if that was going to be the grounds for denial for us, what about our competitors? In Cheyenne, in particular, there are 2 gaming facilities operated by one of the other operators that are located 0.3, 0.2 miles from 2 elementary schools. So it's a fairness question. If we were to be denied by the county commissioners in Laramie County because of the proximity to a school for our project, well, what about the other 2 where their facilities are even closer? So if the city of Cheyenne were to say have a zoning requirement that said you can't be a certain distance from an elementary school or whatever school zone, that's an evenly applied standard. So if we were to apply to put a gaming facility in one of those prohibited locations, our county commissioners could say, yeah, we're not going to give you our approval because you're not in compliance with the zoning ordinance. Or if it's in the county, some of their land use planning documents. So I want to get away from this notion that it isn't just about public safety. I think the counties and cities have broad authority to decide the location of where these facilities are located. And so that might look different for different communities. In some places, a city might want them spread out all over town. That's fine. There are examples of other facilities where I think adult entertainment facilities, for example, can't be located within a certain distance of another one that's pre-existing. We can deal with that. That's a uniformly applied standard. But you might have another community that says, you know, we want these all consolidated and maybe not like a special district for taxing purposes, but we want to put all of our gaming facilities downtown, maybe Rollins. Maybe that's a way to revitalize their downtown. They can do all of this through ordinance. And from my client's perspective, that's a really fair way of enforcing some standards. And if we're not complying with those, then that would be grounds for denial that I think would be very sustainable. Because like if you go back to the Sweetwater County decision, that was the impetus, as long as things are fair and consistent among the operators. So that's our concern, Mr. Chairman, is when we talk about arbitrary and capricious decision-making and the kind of control that the counties and cities want, we are fine with location, size, hours of operation, but where we get really nervous is protecting one operator over another because of that fear of corruption that we saw in Las Vegas, and then just the fear of free market principles and competition. And so I wanted to point out that case in further detail. If you have a chance to read it, as I mentioned, it's in the meeting materials that we provided during the last hearing. As further guidance on that theory, though, of monopoly making creation, it repeated itself again in Campbell County. You had an instance where you had two existing operators that had gaming facilities in Gillette, and then 307 Horse Racing wanted to offer live horse racing. And because the county commission revoked their approvals, the other two operators, and I obviously wasn't involved with that litigation either, but remember this case being a very contentious one when I was in the legislature. There was concern, if you read the briefs, about the creation of monopolies, providing exclusive ability for only 307 to do business in Gillette. And so the courts in the Wyoming Supreme Court did not opine on that opinion, but you'll see it in the briefing. And so if you go to the documents that Ms. Ravalli provided for this particular topic, beginning, it's toward the end of your meeting materials. I'm going to put this on my glasses so I don't get it wrong. I think it's important to think about what we're talking about here. You've already heard that these licenses don't just go to anyone. If you want to operate a gaming facility, your first step is you have to figure out how you're going to offer live horse racing. That's expensive. Whether you build a track or lease a track, that's a significant investment. From there, then you have to do all of these other requirements. You have to make sure that all of your key employees have background checks. You've heard a little bit about some of the back and forth about, financial assurances, feasibility studies, county involvement. But if you read on page 10 of 12 in that last court case, they talk about how the Gaming Commission, not the county, is charged with the authority to suspend, to monitor the amount of money wagered, to monitor the amount distributed to counties and cities, and to fully vet an applicant. Going on later into that opinion, it said, a plain reading of the statute shows that the Gaming Commission is vested with broad authority and that county approval, as required in the statutes, is a condition precedent for the gaming conditions approval. So I think what we're trying to get after is we're making a pretty big significant shift. Either the Gaming Commission has the ability to issue these permits, or the cities and towns and counties. But then the question is, well, what's then is the role of, all of these other functions? And so I just wanted to highlight that. I think that these legal documents actually provide a lot more guidance. But I just wanted to illustrate that is our concern, Mr. Chairman and Madam Chairman, is we don't want to create the creation of monopolies or duopolies. There are so few of these operators that actually have their foot in the door that offer live horse racing, that if we're not cautious in how we write our laws, that could very easily be the case where we exclude other new entrants into the market, which I don't think is what this committee is interested in pursuing further. But I could be wrong. But with that, I'm happy to answer any questions.
Thank you, Ms. Ellis, for your remarks. Are there any questions?
Madam Chair, one further
Yes.
thought. I just looked at Senator Kolb. And it reminded me of something he said. So he just, in his earlier comment, said, they're worried about protecting the live track in Sweetwater County. How it works right now is only the operator, or the only operators only feed their own purse money, is essentially, I think, what is the lay of the land in the state of Wyoming, to our knowledge. Had this 100-mile rule been interpreted as we see it should be interpreted, there wouldn't be that threat of competition, because that competition coming into Sweetwater County would have required Wyoming Downs to contribute to the purses, contribute to the success of the race. So it's the flip argument of what you just said. And I think your comments kind of proved our point exactly, is if there were more true enforcement of the 100-mile rule or application of it throughout the state, I think it would alleviate some of that concern about the track's success. So I'm sorry, I forgot to mention that earlier in my remarks, but just seeing your face in anticipation of that question, I want to make sure I made that point.
Thank you for those remarks. Any comments, questions from the committee? Seeing none, thank you. Any further public comment on this section? We'll go ahead and close this section. And we'll get started with parimutuel wagering, the historic horse racing and local control with current statutes. Mr. Laramendi, Director Laramendi.
Thank you, Madam Chair. I kind of covered some of this already as far as the current status of the local control portion. As it stands right now, state law requires that an operator seek county approval and county approval only. They're not required to get municipal approval or town approval or anything like that. So when they apply to the commission with their application packet, they have to include their a county resolution. I think every application that we've seen has come with a formal county resolution. There is one county that doesn't authorize it by county resolution. They've chosen not to do it by county resolution. They did it by another letter that was signed off by their county attorney, granting the county's approval for that. When it comes to any more on this, Madam Chair, I'd stand for any questions as far as the current status or what we look for or what we do.
Thank you, Director. Any questions for the Director regarding local current statutes on local control? Co-Chair Kolb.
Yeah, thank you, Madam Chair. Yeah, Nick, in particular, I mean, I guess your thoughts on your ability to deal with local control when you have a city, let's say, who is unhappy about the county doing something, which happens. You take testimony on that. Do they comment? Do they put a letter of protest in? You know, and then once again, I'm probably being redundant. Do you feel that you have adequate ability to take that into consideration as a gaming commission about the approval or denial of said permit application? Thank you, Madam Chair.
Thank you, Madam Chair. Senator Kolb. I don't currently right now, I think that we could work on drafting rules that kind of cover some of that as far as protests by the city or complaints by the public or anything else that could be brought to the commission for the commission to investigate and consider and review. As it stands right now, we haven't had that occur. We haven't had a municipality or a county reach out to us from an existing location raising concerns from an operational perspective. We just haven't encountered that yet. But I think we could, work on drafting rules that would address investigations into said complaints or avenues that cities, municipalities, counties, or even the public could, bring concerns to the commission for the commission to investigate and see, what the investigation shows.
Follow up.
Thank you. Yeah, but clearly you lack statutory authority to deny. You can make rules within your sideboards of what the statutes let you make rules about, right? So you can't go beyond statutory authority to make a rule. But I mean, you could investigate it. Sure. I think that's possible. But for you to actually deny an application, you lack, okay, then tell me where in statutory authority you have to deny said permit application. That would be I guess my follow-up question.
Madam Chair, Senator Kolb. So in Title 11, the commission is granted, there's a caveat in the statute that says the commission may issue, deny, or amend permits in their discretion. That's all it says, though. you know, in conversations with our legal counsel, obviously we would have to be able to articulate very clearly reasons for either denial of that or suspensions. It is in statute that says that the commission can issue it or deny it. I don't know if it's ever been challenged or ever been tried.
Follow up?
Yeah, but we would probably consider the Campbell decision in anything that you're going to do, which I hate to use this word, but a chilling effect on your ability to take that kind of action because of legal precedent that's already been set. I mean, what off ramp do you have? I guess I'd like to give you the tools to be able to accomplish this, Director. Frankly, that's one of my goals. That's really my number one goal, is to give you the tools to make those decisions while we work with cities and counties on whether they, agree with a certain situation or not for permitting. But I just don't see you having that authority. I don't want to be, put words in your mouth, but you don't seem to have the tools to do that.
Madam Chair, Senator Kolb, I think the commission would appreciate any extra tools that they can have to deal with some of this stuff. They would definitely like that.
Further questions for the director?
Madam Chairman?
Representative Johnson.
Yeah, thank you. I would just like to say that zoning regulations would solve that problem completely. If a city did not want gaming facilities in their city, they could out and out not allow them to be zoned as a business in the city. I think we're adding regulations and rules that are not necessary. That would allow local control even at the city level. So just throw that out there, and would that work? I think it would.
Thank you for your remarks. Director, does the Wyoming Gaming Commission give any directive on zoning when looking at permitting processes?
Madam Chair, if very few municipalities have any sort of zoning requirements, we have received certain special use permits that have been required as part of the applications, just because the way that the municipality has zoning. But since I've been here, I haven't run across a zoning issue that has prevented the approval of an OTB location.
Co-Chair Kolb?
Thank you, Chairman. This is the follow-up, maybe some information that might be helpful to the committee. You absolutely don't want to have a zoning district that, say, if you had the authority to approve gaming, if you did that, you will then have no control over anything. If they comply with the zoning requirements, they have a use by right for zoning, and that takes away an authority. And currently, statutes absolutely don't allow that kind of authority to be blanketly given out for zoning. I mean, it may be certainly worth a discussion about having counties' ability to zone, and maybe the requirements for certain zoning districts, like, say, a vote by the voters for that kind of activity, which I don't know as we've done that before. But right by use for zoning is a very slippery slope, because it cuts both ways. I mean, it sounds good on one side, but if you look at the other side of it, you're like, whoa, whoa, whoa. If I do this, I have no control, because you in fact have a right by that point, and you can go to court and you'll win. You can't deny, basically, even if they put it, even if something develops in the future that you couldn't anticipate, you get caught. So right by zoning use is a tool that we use for residential, industrial zoning to commingle things in the same location, so we don't have dissimilar activities happening between a residence and an industry. But I think gaming is a very, very unique thing that is highly controversial right now. And, I would caution any thoughts that was a great solution at this point in time. Certainly we need further discussion on it, but I think there's a danger to be considered that maybe we don't look at sometimes when we look at a solution. This my 2 cents on that is educational purposes. And certainly we got to have a conversation. Thank you, Madam Chair.
Thank you, Co-Chair, for those remarks. Do you have any follow-up to those, Director?
Yeah, Madam Chair, I just recalled something that happened actually about 3 or 4 months ago. We had received an application from an operator for a transfer of a location from one to another. And I had prepared the public notice to send out to the cities and counties. And after I sent that out, I actually did have the city contact me to let me know that the proposed new location would have to go through a special use permitting process to have that changed. So I contacted the operator, and then, so we did have one instance that I can recall now to where there was a zoning issue. And working with the operator just withheld that application or pulled that application back while they're working through the city of Cheyenne's special use zoning stuff that they have to go through to make that compliant. And then they'll resubmit the application with the letter from them.
Thank you for that history and knowledge. Any
Madam Chair-
questions?
Madam Chair,
Representative Johnson.
yeah, thank you again. Director, if we allow the counties and cities to issue licenses, aren't we putting value on those licenses, which could lead to other adverse conditions? I'll let you, you know what I'm saying? The commissioners and the cities would then have value in licensing, which I believe could lead to corruption of some sort. And let's just take it off the table and not allow it. Allow zoning to take care of the whole entire matter. That's my opinion. Thank you. Your opinions, please, Mr. Director.
Thank you, Director.
Madam Chair, Representative Johnson. So the way that I understand this to look, it's not the municipalities or the county granting a license. That's the license granting is the sole purpose of the Gaming Commission. The commission is the one that has to grant that license and holds that license. They're just seeking approval or authority to operate within the municipality or the county to conduct their business. But the license is issued by the state, by the Gaming Commission, and we're the ones that control that license.
Follow up?
Yeah, well, that's exactly true. But you would have the commissioners or whoever is involved in that decision would have some discretion one way or another, some variance or whatever. If it's solely issued through zoning, there would be no discretion. As long as you follow the zoning rules, you will be allowed to operate in that county or city. There would be no quid pro quo, no give or take. It would be yes or no.
Director.
Madam Chair, I'm not really prepared to speak on zoning laws. I have no idea how they work.
Thank you for that. Any further questions for the director? I do have one for you. Could you please speak to the current statutes when we're permitting machines, when it comes to HHR? How many are readily available? How many are active? And how many are essentially permitted but not functioning?
Madam Chair, so currently under state law or commission rule, there's no limits or caps on any machine counts. Like skill games is limited to 4 per establishment. The way that HHR operates, it's based on feasibility. These are destination properties. That's the sole purpose of this property. I'd have to grab my, actually wait, I have some numbers in the stuff that I submitted to you. So as it stands today, and I'll break it down by the current 3 operators, Wyoming Downs has been approved to operate 20 OTB locations throughout the state. In the 20 locations, they've been approved for 2,310 terminals, of which 1,146 of those are operational. 18 of the 20 locations are operational and 2 of them are pending. One of them's a new build that would be south of Cheyenne, right off of exit 2, and the other one's in Rock Springs. Wyoming Horse Racing has been approved for 13 off-track wagering locations throughout the state. Their approval includes 2,804 terminals. As it stands today, they have 952 operational. 10 of these locations are open. 3 of them are pending. The important thing with Wyoming Horse Racing and the drastic difference in those numbers is to remember that 2 of their large projects, one here in Evanston, is currently under construction just that way, a little ways. The other one is the Swan Ranch property, and there's an expansion planned for more terminals and a hotel and convention center and everything else with that one. Wyoming Horse Racing has been approved for 14 OTB locations throughout the state, and they've been approved for up to 1,289 terminals. And currently they're operating 1,043 terminals. Of their 14 locations, they have one that's pending opening in Sweetwater County. So that is the current status of terminals.
Thank you. On the follow-up to that question, the ones that are pending, are they machines that are permitted with no space to go into? Are they machines that are just waiting due to construction of facilities? Could you speak to that?
Madam Chair, it's a little bit of both. So there is the larger number is pending construction. So just off the top of my head, 307 Horse Racing is currently sitting on a 600 terminal approval for a new location being built in off of exit 2 on I-25. Wyoming Horse Racing is sitting on 1,000 approved terminals for the Uinta County project, just here by the I-80 exit. And they also have an additional 1,000 terminals that were approved for the Swan Ranch expansion. And that one is going to need construction as well. Some of the other smaller numbers that actually came about from COVID. In 2020, with the whole 6 foot away thing, a lot of the operators had to remove a terminal and put spacers in between the machines to ensure that the spaces were 6 feet apart. So they reduced their floor size, and then those terminals were already approved. They had actually found that their customers preferred that extra elbow room, and they weren't sitting on top of each other. So they haven't put those terminals back into play in those locations, but they were approved for those.
Thank you. One follow-up to that, maybe with those terminals that have been taken out for spacing issues, can they move those from location to location, or are they permitted specifically to an address?
Madam Chair, they're permitted for that address, but they could apply for additional terminals or moving terminals between those locations.
Any further questions from the committee? Co-Chair Kolb?
Yeah, thank you, Chairman. Nick, when you have the number of terminals per operator, I know I've been there when you show the analysis of population and saturation, but there's no, is that just like an exercise in statistics to show those numbers? Because I hadn't heard you being able to disapprove said application because of population basis. I guess I would like to know, have you denied any permit requests for more machines? I guess if I'm using the right nomenclature here, or not, or have you approved all? I guess, what's the history? Have you disapproved any machine applications for the number of machines per capita? Thank you.
Madam Chair, Senator Kolb, we have not. Every application that's come through for a terminal addition has been approved. And I think part of that is there is some concern from the commissioners of the ability to deny those requests, or what that looks like. What do they point to deny those requests?
Follow up. Representative Webb.
Thank you, Madam Chairman. If my math is correct, there are about 6,400 that have been approved. In use or operational is about 3,100, so about 50% of them. Do you have statistics on the usage of those machines, of the current machines? That's a lot of machines. We're looking at, what is that 1% of machines versus the total population of the state of Wyoming? Do you have statistics on the usage of the machines, the 3,000 that are currently being used, and do we need those other 3,000 operational?
Madam Chair, Representative Webb, so we don't track it on a per terminal. We look at the wagering activity per location. We could drill down on, and I could get you the data. Actually, I can get it directly from the tote, and it'll show you every terminal and which ones are being played and which ones are being not played. I will say that, you know, from an operational perspective, the operators have to pay for these machines to be on the floor. So if the machine ultimately is not making money, they're not going to leave it on the floor.
Follow up?
No, thank you.
Thank you. I do have one question for you, Director. Aside from the local control within municipalities and the counties, has there been any other unintended consequences from our current legislation that you're finding challenges to with the Wyoming Gaming Commission?
Madam Chair, I'm not quite sure I understand your question.
We're kind of hyper-focused on local control right now. Does the Gaming Commission find any other challenges in their current permitting process or the operation of gaming in Wyoming, given our current statutes?
Madam Chair, I think one of the ones that we're challenged with right now will be covered tomorrow, and that's the criminal enforcement of statutes. Currently, right now, like as we spoke of earlier, I think the commission would gladly accept any sort of guidance or tools that they have to maybe check out and, you know, really focus on some responsible growth in the market. I know that that's been a topic for several years, is the responsible growth, and it's exploded even since I've been here. Since 2019, when I started with the commission in 2019, we had 13 OTBs. We now have 45. In 6 years, we've added 32 OTBs. We did add another operator, and now a fourth operator coming into the market. So that's part of that growth, but it's definitely exploded, and I think the commission would use any sort of guidance, and they would accept that with open arms for sure.
Madam Chairman?
Yes, Representative Johnson.
I would just like to suggest that maybe we limit the amount of machines to a track, to whatever track they are connected to. Say 2,000 machines, 1,500 machines are throughout the state. So if you have 3 tracks operating, you would only have 4,500 machines. I think that would, my thought is that some of the lesser off-track betting places that are in lower income districts not making money would be discontinued, and they would move to the higher value tracks or places of business. What are your thoughts on that, Mr. Director?
Madam Chair, Representative Johnson, I think that's a policy decision that you're all welcome to make. I know there has been discussion on the Gaming Commission side. Just a few years ago, there was some discussion of, you know, attaching the amount of terminals to the number of race days. I think when we first started looking at it, we were talking about, you know, you get one terminal, or let's see, what was it? One terminal, or no, 80 terminals for every one day that you operate a racetrack. So if you operate, you know, 16 days, then you get whatever the math is. Horrible at math. But, you know, it'd be 80 times 16. And then if you want to expand your HHR offerings, then you'd have to run more live horse racing days in order to suffice. The question that came with that was, then you have an operator that, say, you know, applies for and runs maybe 24 days one year for all those terminals, and then the next year they only run their 16 days that they're required to run. How do we, you know, pull those approved terminals back? But it's definitely a topic that's been discussed before, as far as, you know, limiting terminals based on either population or track operations. However that looks, I can provide any information that may help in that discussion for sure.
Follow up? No. Representative Webb.
And mine's more of a follow-up too. Thank you. I would like those statistics. We didn't answer that question. I would like you to grab those statistics and present them to us as far as usage.
Madam Chair, Representative Webb, I'll get those.
Thank you.
Co-Chair Kolb.
Yeah, thank you, Chairman. I do like your idea on race days to terminals. I am a little baffled on why they were hesitant because of race day change, and they would have to then not operate as many machines. And I guess my follow-up question is, so what? So what? That's their choice on how they want to have the race days. And if they realize that that's the ratio they have to maintain and keep those machines running, then they're probably more incentivized to have more race days. I mean, barring, I suppose, some sort of other event that maybe precludes them from doing that, like some sort of outbreak of something. But was there anything else to that? Nick, these are things that I would like to hear that you folks have already been discussing on the Gaming Commission for probably years. But these are things that we need to share between this task force and you folks, that we know that you've looked into this and you've already kind of gone down that road. Because I think it's very valuable information, at least I think to me and probably to everybody, of what you've done and what you've looked at. And because I know you haven't been twiddling your thumbs over there. I mean, you've been trying to do things, but share the information. I think we'll all be better off with more data. We can make a better decision because maybe you've already, gone down that road and found out, well, there's a problem here, a problem there, and you didn't want to do it. But we do have to have some way of wrangling this problem and getting our arms around it. And this is one methodology that sounds interesting to me, at least right now. Like, why couldn't we do that? And go back to what I said. I don't care if they can't run as many machines because they don't have as many race days. So what? I mean, that doesn't sound like a reason not to do it. So I guess maybe you could have more information on that. I think that's a valuable off ramp to what we're talking about. Unless maybe you could elaborate on another methodology that was tried or thought to be tried that you think may have some prospects on working. Anything like that is something I think is just great data. So thank you for sharing that, and thank you for Representative bringing that up. I think it's an important point that we talk about. So just your 2 cents on that, Nick. Do you think it's dead? Do you think it's worth bringing back as an informational point of control?
Madam Chair, Senator Kolb, I would be happy to share the draft rules that we were working. So really what happened with that was, I think this was last year, or maybe the year before, we were looking at a lot of draft rules for HHR limiting, and actually the commission was kind of maybe directed to slow down a little bit to see what the legislature was going to do. Because at that time, the legislature was running 5 or 6 different bills about limits and controls, and we didn't want to get things too in the weeds. So the commission just kind of pulled those back, but I can dig those out and I can share them with you. And there's some good thought in that. And I think that it was a really good way to ensure the tie between HHR machines and live horse racing, because they are directly tied together. Every terminal, or 5 terminals or 10, whatever the number may be, is supporting a track or a race day. So.
Follow up?
Yeah, thank you. Just one last thought. Don't ever outthink the legislative body. We won't get anything done typically. So, and maybe that's by design, but we still need your help, and that would be my point. Appreciate your respect towards the process, but we got to come to the table with solutions, and it sounds like you've got something we can talk about.
Madam Chair, Senator Coble, I'll get that stuff today for you.
Thank you, Director. One follow-up question would be for the permitting of these HHR machines. Once they're permitted, is that in perpetuity, or do they have to continue to apply for said number of machines per year? Or is that also on a 3-year application process?
Madam Chair, so once the terminals are approved, it's in perpetuity. They have to pay I want to say it's they have a fee. I'll have to look it up. They have a fee that they have to pay every year for the operation of the terminals, but the terminals in and of themselves don't hold a license. We just keep track of the counts and the serial numbers at the locations to ensure that they're operating within their limits that they've been approved for. And that's it. The permit itself that they apply for, the 1 and 3 year, that's their, like the overarching permits for offering live horse racing and simulcasting. So, you know, if something were to happen, for example, the way that the rule is written, you have to have a live racing permit before you can even apply for simulcasting. You have to have live event permit. So if an operator today who's operational has applied for their 16 days of live racing and they fail to run their 16 days for a reason that's not an act of God, say they run 12 because they just don't have the money or they don't have the people. The commission, under commission rules, they shall lose their simulcasting abilities for the remainder of this calendar year and all of the next calendar year. So those two are tied together. So that's really the only, in our rules currently, that's really the only shall deny simulcasting is the failure to run those 16 days. So if they, when they renew their simulcast permit, then that just carries on all of their OTB operations that they currently have.
Thank you for that.
Madam
Further
Chair?
questions from the committee?
Madam Chair,
Representative Johnson.
I would just like to throw out that there is a new track being under construction in Laramie County. And my whole reason to be on this committee is to improve horse racing, make Wyoming a horse racing state and compete with Kentucky. I would like to know if we limited the amount of terminals to a track and not to the racing days, we could still expand that. We could have four, looks like we're going to have 4 tracks available. It would not limit the amount of tracks coming into Wyoming. And the reason I'm saying this is that once you get horse racing in here, you have people that clean the stalls. You have all sorts of people that feed the horses. Agriculture produces hay and oats, and veterinarians are employed. I mean, this is more than just a gaming facility on the interstate. It provides jobs throughout Wyoming and in different sections of Wyoming. So I would just like to throw that out there, that maybe we should just have them limit games per track and not per race day, because eventually we're going to have, hopefully we would have race days throughout the year, potentially. So I'll just throw that out there, and your comments, Mr. Director.
Any comments for those remarks?
Madam Chair, I think we're open to any discussion on how the best way to approach it would be.
Thank you. I would like to follow up with a question about track safety. Are there any current laws that are a struggle for the commission when it comes to track safety? Does the commission feel confident in their ability to adequately permit and run tracks at this time?
Madam Chair, thank you for that question. I think the commission is very comfortable with the safety issue of the tracks. A couple of years ago, we had a bad year. It was a really bad year on the horse racing track. We had too many catastrophic breakdowns on the track. The commission immediately put together a safety committee and started researching and meeting and implemented emergency rules to address safety concerns at the racetrack. We went through the emergency rule process. Those have been all promulgated now and are standard rules as far as, you know, and it talks about the biggest one for this is every operator has to conduct a third party has to conduct a safe track racetrack safety inspection prior to their meet. And every track has to do it. So we contract, the commission contracts a company that comes and they spend days. And as a matter of fact, they're in Rock Springs tomorrow, and they're going to start doing the Rock Springs track for the next, and they'll be there for 4 or 5 days. And they're taking soil samples, they're testing, you know, the surface, the cushion, the stalls, everything involved in the racetrack. They're reviewing to make sure that it's safe. So the commission does feel very, very good about the safety. And this year, I mean, I think last year After we first implemented that, the catastrophic breakdowns dropped by like 87%. So, and we're on track to be even lower this year.
Thank you for that. Co-Chair Cole.
Yeah, thank you, Madam Chair. Yeah, just could you edify the public on what you just talked about as a catastrophic breakdown? What is that in layman's terms?
Madam Chair, Senator Kolb, so a catastrophic breakdown would be ultimately a horse dying on the track. Yeah, you know, it usually happens with some sort of an injury, a broken leg or something like that. Sometimes it's unavoidable. I mean, it's hard to know if a horse has a pre-existing injury or pre-existing fracture or something that's not detectable. One of the other things that we do every race day, our poor vet has to check 100% of every horse entered on the racetrack. So every horse that is going to be out on that track that day racing has to go through a racing soundness exam that's done by our commissioned vet. He's been the vet for the state, for the racetrack vet for the state for well over, I want to say 15, 16 years, I think. So he's very knowledgeable in racetrack and equine athletes. So we do everything that we can to avoid that, but occasionally it does happen. It's important to remember with horse racing, that's, I think, the only sport that an ambulance actually follows the athletes around. There's an ambulance driving right behind them the entire time. So it doesn't happen in any other sport.
Thank you. Further questions for the director? Thank you, Director. At this time, we'll open up this section to public comment. Are there any public comments online or in the room? Public comment? Seeing none, we'll close this section. We'll move forward to the next section, which shall be parimutuel wagering, historic horse racing, and local control policy alternatives. Ms. Tamra.
Thank you, members of the committee. You're right on time for our next topic, and you have a memo that was put together after the committee's last meeting. I think for context, we were talking about House Bill 185 from 2025 and the status of that bill and whether to bring it back or whether to consider some other options. And so the terminology used by this committee at the time was they wanted to see a matrix of policy options, some ideas of how historic horse racing could incorporate local control. And it was limited to that in the scheme of gaming and gambling. We were talking about historic horse racing terminals or simulcasting and the local control aspect of it, not just regulating historic horse racing generally. And so I did some research trying to look around through other states to give you some ideas and some options. And I did have to look to other types of gaming because historic horse racing is more limited across the United States than other types of slot machines or video poker or video bingo. And so it's limited to a number of states. And then in those states, it is somewhat of a top-down policy that exists. There are some aspects of local control, and I'm not going to say that all of the other states, and I can talk about this a little bit too, are exactly like Wyoming. In fact, Wyoming's different. We run historic horse racing differently than many other states, probably the most similar to Kentucky. But so I had to look to other types of gaming, and I'm well aware of the criticism that there may be other policy objectives for video bingo than there is for historic horse racing. Video bingo, they're not trying to bring back a live horse racing industry, whereas historic race racing as a policy is tied to that. So I'm well aware of that, but I think they can still offer you some mechanisms to understand how other jurisdictions have approached local control within their gambling laws. So, that said, I'll go into and dive into some examples quickly. I found that some states allow for regulation at the county level or at the municipal level. And so their state law specifically will empower governmental bodies to set up gaming policy. And that results in different ordinances or different codes for every municipality. And the way that Alabama has video bingo was one example of this. So could be hundreds, there weren't hundreds, but could be tens of different codes on what you need to do to have video bingo in your establishment or to start as a video bingo operator. The Director Laramandy actually brought to my attention Maine has an aspect of this regulation at the county or local level for their simulcast, their off-track betting locations, but they don't have historic horse racing. So they're truly just betting on races that are being broadcast live. And that statute requires that in order to get a license, you must have had approval from the municipal government. So it's sort of similar to Wyoming, but it is more well-defined. There's a little bit more there to go on if you wanted to look at their statute. I can provide you that text. The next policy option I saw that was interesting was to require community benefit agreements as licensing criteria. So their commission, for example, in Massachusetts for casinos, will not issue a permit to have a casino unless the operator has entered into host agreements with local governments, determining the parties' responsibilities, their fees, and just kind of setting forth all the things that need to be worked out. They also require some of those applicants to enter into agreements with other live vendors. So some host, that means the local governing body has to get kind of an MOU, local host agreement, and even some of the live venues that are going to might lose business will have to establish agreement. Then I did look a lot to try to find some good examples for zoning or land use regulations, because that seemed like it was a topic of real interest to this committee. Are there other states that are really allowing this to be done through zoning and land use? And the research didn't show a lot of state examples that, really holistically put all the authority in zoning or land use. I did find some examples here and there that either explicitly or inherently left it up to zoning or land use to regulate gaming. There was an example, the city of Myrtle Beach limited their poker machines to accessory use. So rather than opening up a casino in Myrtle Beach where you come for the destination of playing video poker, the city said it can only be accessory use. That means it can't be more than 40%. You're a bar, as an accessory, you have some of this. So it's hacking it on to another business. That was litigated and it was upheld under their statute. Another example was Louisiana state law grants zoning authority over video poker establishments specifically. So they did not rewrite their whole zoning code, but they did put in a little bit more specificity for video poker within their zoning requirements. Another example, my last example on this was with historic horse racing, and I did see that the Kentucky City County Planning Commission of Warren County had, in order for a new gaming establishment to open where it wanted to open, they were going to need a developmental plan amendment. And that was denied by the local planning commission because of zoning. And so that is more of evidence of their overall zoning laws in general. It just worked within the structure. There's no state law that said by zoning, you can go ahead and prohibit establishments from developing within development zones. That's how that worked out. Then as policy option number 4, I did find examples of states requiring voter approval or referendums for gambling. And this is similar to Wyoming's statutory requirement for voters to approve parimutuel wagering generally. So each county at some point in time has to put it on the ballot, and the county voters have to vote to approve parimutuel wagering, which used to mean horse racing. And then it meant perhaps simulcasting and rodeo events. And, it's grown until now. When parimutuel wagering is approved, that means historic horse racing is also approved. But some counties or some other states are more strict in their policy where you require specific franchise approval. So the voters vote in Arkansas for every skill-based amusement game establishment that's going to come in. Or in Massachusetts for casinos, the voters vote for each license that's going to be issued. So it's not a one and done. It's a every time there's a new license coming up or establishment, voters are having more control. In Virginia, for historic horse racing, they do have to vote specifically for off-track betting or on-track betting with historic horse racing terminals and simulcasting for each facility. So it is very specific. It's not just parimutuel wagering, yes, no. It's, do you approve off-track betting or do you approve historic horse racing on your tracks? They're having a little bit more control by the voters.
Could we
And-
interrupt for one moment?
Sure.
Senator Kolb has a question.
And before you, thank you. Sure. Yeah, before we get too far down the road, this specify, are we talking about a referendum per county or per state?
At the local revenue, Mr. Chairman, either per county or per municipality.
Okay, thank you for that information.
Let's see, Louisiana, similarly for historic horse racing, it's effectively banned by judicial interpretation, but before it was banned and earlier this year, they required voting approval for parimutuel wagering. And the reason that the Supreme Court of Louisiana found that it was banned is that the Constitution of Louisiana requires voters to approve each new type of game. And they said, that court said, historic horse racing terminals is not parimutuel wagering. This is a new type of game. It kind of looks like a slot machine. This is something that voters need to approve. So just because they approved historic horse racing under our Constitution is not going to satisfy that requirement. And so if Louisiana wishes to continue, and I suspect they're deciding what policy route they'll go after the judicial decision, but if they wish to continue, they're going to need to have the voters specifically approve historic horse racing. It wasn't good enough that they approved parimutuel. Those members of the parish approved parimutuel wagering at one time. Then the last option I'll talk about is just a broad policy idea is to have an opt-out. This is rather than an opt-in, an opt-out. It's legal unless the voters or the local government decides they don't want it. One example was Illinois with video gaming terminals. They can pass an ordinance to prohibit, or voters can put it on the ballot by petition that they want to prohibit it in their locality, county or municipality. Pennsylvania approached this uniquely too when they authorized video gaming terminals. They gave certain categories of counties that already had casinos the option to opt out, but they limited it to 60 days. So you have 60 days to pass a resolution to opt out, or you're going to have video gaming terminals in your jurisdiction. And they allowed them one chance to take it back, to rescind the opt out and opt back in. And that was it. So time limited, kind of came with we're passing a new policy. Let's give you some input at the local level, and then that's what it is once you make a decision. So I don't know if that was quite the policy matrix that the committee envisioned, but it's sort of what I came up with. We've already heard a lot of ideas and recounting of things that have been tried in the past, and I can absolutely bring back all of those types of ideas if the committee would like to see them explored in bill draft form, or even just explore it as a policy. We know what would this result in. We can study those. Absolutely. I do have examples of historic horse racing because I am sensitive to the criteria that, that's all academic and good ideas. Anything is unimaginable as a matter of policy, but that's not going to work for historic horse racing because we do have policy goals we want to achieve as a state for historic horse racing. And so I did want to tell you a little bit about how other states regulate historic horse racing and their off-track betting or on-track betting. Briefly, if that's within my time, I included this as table 2. It's within your July 25th memo to the entire gaming committee. And I just looked over at other states' experiences with historic horse racing terminals, less focus on local control, really across the board. Other states with historic horse racing are less focused on local control than they are overall growth. And what we see in a lot of other states is more restrictions on unlimited growth of historic horse racing. Wyoming and Kentucky are some of the most laissez-faire when it comes to regulating that aspect. So 3 states tried historic horse racing, and they either legislatively backtracked by repealing it, that was Idaho, or judicially ended up prohibiting it. This was Louisiana, who said, you didn't follow our constitution. Voters need to have a chance to weigh in on the historic horse racing terminals, or by executive branch interpretation. And that was in Oregon, where essentially their attorney general found that it did not comply with their constitution, what the legislature had passed for historic horse racing. I found that one state used to have historic horse racing, but when they legalized casinos by ballot, but the voters in the entire state decided to legalize casinos, that was Arkansas, that those have sort of fell out of favor, and there's no cited. At least I couldn't find any evidence that they were still continuing now that the casinos were an option. One state has a moratorium until 2031 on the expansion of historic horse racing terminals. That's New Hampshire. Then 2 states have locational restrictions. So they either, you're not seeing off-track betting, you're only seeing on-track betting. So you go to the horse races, you're there in person, horse races are going kind of slow, or there's some time between horse races, then you can play the terminals while you're there. But the terminals are not allowed to be out at simulcast facilities, and that's Kansas. Kansas has historic horse racing, but it's limited to 1 county, and there's only 1 racetrack in that county, and it's only on the premises of that track. So you're not seeing the number of locations as compared to Wyoming or Kentucky. Then another example of that locational restriction is Alabama. They only allow their class 1 cities to have historic horse racing. That's their very large cities, over 300,000. 3 states also require voter approval. That was Alabama, Virginia, and Wyoming at some aspect of voter approval. 2 have numerical caps. That's Kansas and Virginia. And I think that captures what I found in the other states with historic horse racing.
Thank you very much for all of your research that you put into this. It's a great deal of knowledge that you're willing to share with the committee. Committee, any questions? Co-Chair Kolb?
Thank you, Madam Chairman. Just on the idea of voter approval, I can tell you what smacks me as kind of a bait and switch is that we had a voter approval, there was a vote that brought in gaming into a county, right? And we now don't have that same vehicle of gaming. It changed. I'll just arguably it's different than it was when they voted. So is there in your mind a mechanism that we could mimic other states to basically reauthorize said new forms of gaming, either as a blanket statement for say a county, or more specifically to a type of gaming that would, because clearly in the past they approved what we had before we had all these HHR machines and all these other mechanisms for gaming, but no one's had a chance to approve any of the new style, the new games, the new product. So I guess your thoughts is there anything that would be restrictive about us coming up with legislation that would, in fact, mandate that they would have to approve a new style form of gaming that they never, I would argue they never approved some of this stuff that we have now. The legislators just did it under the umbrella of, well, you approved gaming at one point in time. And so forevermore, we'll make gaming whatever the heck we want to make it. And it'll be under that same umbrella of approval. I just don't know if the voters had a fair shake at this to say yay or nay. And I'm not, trying to game the outcome. I'm just saying that it doesn't seem fair if I was just a regular constituent that all of a sudden, if I did vote on this years ago, what I voted for wasn't what we have. It doesn't seem like it's the same product to me.
Madam Chair, Mr. Chairman, that's a really great question. And I think your question is, can we put it back to the voters? We already have the status quo of what's going on. Can we put it back to the voters and require a new vote to continue to allow historic horse racing. And yes, I think the legislature is the body, the policymaking, the legislating authority that has that ability to decide the policy of gaming. But that said, it is complicated to change the status quo. And there are, of course, rights involved. But all of the case law that I have researched about a legislative body to change policy and law is pretty open, because you are the body that can decide what is good for the people. And to that, if you decide to require another vote, there will be challenges. You'll need to do it fairly, need to carefully think about how it's going to affect existing rights and existing contracts. But generally, courts and the Supreme Court has said with something like gambling, there's not a public policy right to have a horse track generally, or and I know there are plenty of property rights involved, but as a matter of policy, I think the courts have said that, there's ability of the legislature. Now, there's less ability of county commissioners and less ability of the gaming commission and municipalities to up and change the law. But by state statute, you can regulate gaming authority. And if you want to send it back to the voters, I think there's a lot of ways you could craft that.
Follow up?
Thank you, Madam Chair. Yeah, so it wouldn't be a taking. I mean, if you go up for a renewal and let's just say the voters have said no more of a certain kind of gaming that you're now doing in a county, then you don't get your permit renewed, right? And I thought that was clear that they have the authority not to renew it. In that case, once a permit has run its course, that you can deny the permit because say the voters have said no. At that point in time, I'd agree with you that you can't just have a taking and take away their right once they have a right with a permit being issued. But clearly, do you see a bright line there when it comes to like the expiration of said issued permit, when it comes to a change in, say, a voter referendum, just for argument's sake?
I mean, this is an opinion and it will vary, and it's going to be very fact specific. But yeah, I certainly think you're going to run into less issues if you're only changing policy prospectively. When you renew or when you apply new, this new thing is going to apply to you. But where gambling in general is a crime, if the legislature decides to change what is a crime related to gambling and to change what is allowable as gaming, that's within their authority to do so immediately. But I would certainly recommend you go prospectively, just because of contract rights and taking issues, and just easier probably policy wise. But if the legislature needs to absolutely stop something that they find to be a crime happening in the state, that's legislative power. That's why you're elected.
Follow up?
Yeah, I better clarification here. I'm not calling it a crime. I'm just saying that the folks that voted for something years ago didn't get the same product today. That's my point. And I'm concerned, and it would be a public choice, not my choice. The choice would be do we allow the voters to make that choice? Because it's their community, it's where they live, and it should be their choice as a majority rules when it comes to these type of questions in a voter initiative. That was kind of my point of view. Just to be clear, I'm not saying I'm not trying to get rid of gambling. I'm not. I'm just trying to make it fair and make it representative of what the people want.
Thank you, Mr. Chairman. And Madam Chairman, if I can follow up, that's an absolutely great point. And the only reason I read in criminal statutes is because I do believe that the police power in an industry like gaming is different than in some other industries, like the regulation of hospitals or the regulation of other areas of law. We are dealing with exceptions to all of the gaming that's currently happening is all under exceptions to gambling statutes. But thank you.
Thank you for that. Committee, more questions? I do have one for you. In state statute for Wyoming, is there a direct timeline that said they voted on parimutuel wagering at one time? Is there a direct timeline on when that should return to the voters?
Madam Chair, I don't believe there's any explanation of that in statute. I believe it's just no parimutuel wagering shall be conducted unless approved by the county in which it will happen.
Thank you. A follow-up to that would be, was there directive on how that might happen? Say, is it a ballot initiative, or is it from the county commissioners, or is there any directive?
The county commissioners may have more ideas about that, but I don't recall any statute. This came in when parimutuel wagering in general was authorized in 1967, and I don't recall any contemplation of it ever going back to voters.
Thank you.
Madam Chairman,
Further questions?
Madam Chairman.
Representative Johnson.
Yeah, if you could explain to us, is there a way for the citizens to petition to bring this on the ballot if they want to exclude gambling in their city or county? And what is the process, and what are the requirements?
Madam Chair, thank you, Representative Johnson, for the question. I believe the only mechanism would be a statewide ballot initiative. Perhaps and it would apply to all counties. It would be statewide, but it would require the necessary signatures be gathered. Then it would be voted on, and if enacted. So like any other ballot initiatives, we've had the recent ballot initiatives related to the homeowner's tax exemption. Prior to that, I think there was one related to marijuana legalization. And so it would be through one of those statewide ballot initiatives would be a way for voters to change this. I'm not sure that voters could put back on their individual county ballot, but I can certainly look into that more. Approval to or revoke, disapprove. It's sort of just written as an opt-in.
So
Follow up?
I mean, that's what I'm asking is, wouldn't it be simpler to allow the citizens of a city or a county to petition and not have a statewide petition, but just in their communities? Would that require a state law, change of state law? What's required for that? Thank you.
Yeah. Thank you for the clarification. I believe that would require new legislation.
Okay.
Senator McEwen.
Thank you, Madam Chairman. I'm kind of scratching my head, so I need some clarification. Don't we have 7 counties that already do not allow parimutuel betting? Wouldn't that be done at the county level? Thank you.
Madam Chair and Senator Bowen, that's right. Those counties have had it on the ballot, I think, in some instances, but it's never been approved. So throughout the history of time, it's my understanding that they've simply never approved parimutuel wagering by vote. And so that's where their status is as a non-wagering county.
Follow up?
Thank you, Madam Chair. I guess I'm looking at this and the counties are controlling what's going on. How can 7 of them disallow it, which would leave 16 of them allowing it? Do you understand what I'm saying?
Certainly, I can try to readdress that. What I suspect happened was when parimutuel wagering, when they decided to allow horse tracks, horse racing in Wyoming, they wanted some aspect of local control, likely, and that's where the law was written that said, in order to have this in the county has to approve it by vote. And some counties simply have never approved parimutuel wagering by vote.
Follow up?
Yes, Madam Chairman. I'm not trying to be like a dog on a bone with this, so I apologize for that. But it appears to me we have 7 counties that don't allow it, 16 counties that do allow it, and the counties have to bring it on themselves by voting in the county. So I'm not sure why we need a state statute when the counties are already doing it on their own. And I guess that's the crux of my question that I ran around the bush on. Sorry about that.
Generally, Wyoming law will apply. We have in our constitution, we require our laws to be general, to not be specific. So we couldn't really write a law like Kansas is where it regulates one county. So the general law is that parimutuel wagering, racetracks are going to be allowed. This bill comes about. It's going to apply to all counties. Then that would be the status quo. The legislature would generally authorize it in the state. But then they went in and made that specific exception to say, you know, counties, we want you to have some aspect of local control. As sovereign arms of our state, we want you to have some aspect of it, and we want you to put this to the voters. And so that was just a policy choice. So it is the state law that is giving counties any authority over historic horse racing, because otherwise the state law would regulate the entire field.
Co-Chair Cole. Oh, follow up with McEwen?
Okay. So state law allows it for all counties, but then the counties can vote to accept it or not accept it. So I understand Big Daddy states giving them permission, but they have to go seek it out and vote it up or down. So doesn't the counties actually have a little more control than we think? And I will leave it at that.
Ms. Tamara, would you like to address him, or would you like Co-Chair Cole to?
Well, the LSO talked.
The statute is specific to allowing counties to put it on the ballot to vote in that county. And so that's just simply a policy choice that they said counties, you can vote on this, not you can approve it or you cannot, but parimutuel wagering is only going to be allowed and permitted by the State Gaming Commission if the county has had it on their ballot and voted to approve of it. And you can change that statute as a legislature.
Yes.
Co-Chair Cole.
Yeah, thank you, Madam Chair. Put on my old county commissioner hat and explain why it works like this. Counties do not have any authority to write a statute, to change statutes. The authority we're granted is to follow statutes. And it's dubious at best because of reading between the lines. So the counties, it's out of their wheelhouse. They follow state statutes. That's the way Wyoming is, constructed on how we authorize authority. Actually, counties are an arm of the legislative body. They enforce legislative rules locally, and they make local choices, with the sideboards being state statutes. That's why they can't really do much about this when it comes to if the state statute's written that once it's approved, it's approved in perpetuity, which is what we're saying here, minus a statewide referendum. The only avenue we have to remedy the situation is to give them that authority to say put it on the ballot, or to make another decision than saying once you've approved it, which happened maybe before people were even in this room. Some of them were even in the state. They have the authority then to make other choices. But until we give them that authority at the state level, they don't have it at the local level. That's kind of the short Reader's Digest version of why they just can't run off and fix things that I think is pretty obvious too. But that's the reason why we're here talking about it. But I think at one point Jeremiah would probably comment about this, being he's the County Commissioner Association director. So that's my 2 cents on it for being involved with it for quite a few years.
Thank you, Co-Chair Cole, for that. Representative Johnson, did you have a question or a remark?
No, I agree that we need to allow citizens to choose to disallow gambling in their communities and whatever flavor of gambling that they dislike. We need to give the citizens that right.
Thank you for those remarks. Ms. Tamara, you spoke about Myrtle Beach and the way that they were using this as an accessory and not as a predominant business plan. I want to go back to the skills gaming codes that we currently have in Wyoming. Could you walk me through how those sideboards came about that are in that legislation? Are you aware of that, or shall I bring that up with some of the operators?
Madam Chair, I lived through it and was working on the House side when the amendments were being passed and when the legislation was going through. And so I have a recollection, but it won't be perfect. It did come about in recent years. This is something that, happened. It started. Skills-based games were allowed. And this was before the legislature had acted. And so there was debate about whether these were illegal gaming devices or not. And so at that time, it prompted because these were popping up in bars out there in Wyoming. And I'm sure the director and other individuals in the industry knows a great deal about that history, more than I can remember and more than I've ever forgot. But then the legislature decided we're going to need to do something about this and bring a law. They did bring it in through grandfathering. There were provisions in there that recognize, especially where they first brought in a law to allow skill-based amusement games. It was very contentious, very amended kind of legislation that ended up passing, had to come back the next year and sort of rework it. There was a scrivener's error at that time, which ended up repealing some of the code related to skill-based gaming that wasn't intended to be repealed. But the legislature came back and fixed that and put in statute the current regulations. And so there was more growth at that time. The discussion in the 2019, 2018, 2020 was a lot about skill-based amusement games and whether there was too much of that going on. And so through several legislative sessions and a lot of back and forth, the legislature did end up passing the 4 terminals or devices, gaming devices per location. And now we still have debate over, last year we saw a debate about what's a location or an establishment. The legislature also changed the definition of establishment and allowed truck stops to be in. That was one of the latest changes. So it developed over, 4 or 5 years and was in response to the market of what was actually happening and what industry and the public wanted to happen and what legislators wanted in their communities.
Thank you for that explanation. Committee, any further questions? Seeing none, it looks like you're out of the hot seat. Thank you very much. We'll move on to public comment at this time. Is there? Actually, I'm going to hang on to public comment, but I'm going to invite Jeremiah up to speak to us from the Wyoming County Commissioners Association.
Thank you, Mr. Chairman, Madam Chairwoman, members of the committee. It's great to be here. If I can just take a little privilege quickly, I want to just say we have currently 15 congressional staffers that we're hosting in the state of Wyoming, and they started in Natrona County, went through Fremont County. They just left Sweetwater County and are in Carbon County right now. So I want to just say that 2 of you, your counties, really represented well in that tour. It's a very engaged group, and we look forward to continuing to dialogue with them. This is the 4th of 5 tours that we have committed to, going to every region and every county of the state. And so, again, just a compliment to your 2 counties for the successful trip to that part of the world. Madam Chairwoman, was trying to keep my comments to as few times to come up here. I'll just focus on the election piece here, but happy to take any other questions that you might have. So in terms of the election authorization, that particular statute is 1125-206, and that's specific to historic horse racing. There's not a similar provision for skill-based amusement games or the other forms of gaming that exist out there. That particular statute is 2 sentences. It just simply says in the first sentence that you can't have parimutuel wagering in a county until it's been put to the voters. And the second sentence says if the election fails, it can't be put back to the voters for at least 2 years. So just digging into that a little bit, you've heard that there are 7 counties that currently have not had a voter approval. Those 7 counties, as I understand it, are Park, Bighorn, Washakie, Crook, Niobrara, Sublette, and Lincoln counties. Digging a little bit further into all of that, there was some question about petitioning the commissioners to put it on the ballot. The legislative authorization or the language doesn't say that, doesn't say if the county commissioners. So it's, I guess, possible to read it that either one of those are options to put it out to the voters. Now, in terms of that election, I'll just use a couple of examples. Park County did put it to the voters roughly 2 years ago, and they rejected it and did not authorize it. So they're in that period of 2 years where they can't put it back to the voters. I don't know if the commissioners would ask for that to be back on the ballot, but that's just a note there. Now, of the other 16 counties that have had a vote to approve it, most of them have terminals in their communities, but I'll use one example. It's one of the first counties that actually approved or had that voter approval back in 1967 is what I have in my head. That's Teton County. They don't have a single terminal there. Why don't they have terminals there? Well, it really goes to the next part of this, which is what can they approve or disapprove, which is part of the reason that we're talking about the bill that we will later, and I won't get into that. But I just pointed out as a community that 5 or 6 decades ago made that decision to say it was acceptable, but has never actually moved forward with authorizing terminals in the community. So, Madam Chairwoman, with that, I hope that helps a little bit on this. I guess I will just say one other thing. There is no provision in that title that I mentioned that allows for, say, a Teton County to put it back to the voters and undo what was approved all those years ago. So again, with that, I'd stand for any questions.
Any questions? Co-Chair Kolb.
Thank you, Chairman. Morning, Director. I guess, could you elaborate on this? Because it was on the ability to approve. I mean, once there's a voter referendum and says they approve. My understanding was that once a Board of County Commissioners approved a venue, or the ability to move forward for the Gaming Commission to approve a permit, that once you do that, you can't disapprove the next one because you've approved, as long as they meet the same criteria. So it was really a 2-part system where the voters goes to the ballot, the voters approve, like with Teton County, but if they never approved any venue to get a state permit, then they're safe because then they're not forced to approve anymore because they never approved one. Well, I guess what's your understanding about how that actually functions under that scenario that I just laid out?
Yeah,
thank you.
Madam Chairwoman, Co-Chairman Kolb, I look at it the same way. It is a 2-step process. One, you have to have that voter approval. Second, then you have to have the county commissioner approval to authorize the activity. I think you're taking it a step further in that, okay, now that you've authorized one, what is your authority relative to the second? And I think the Sweetwater County case kind of suggests that once you've approved one, you really don't have much latitude to disapprove others. And we've heard about monopolies and other things. Maybe there are some good social reasons you might be able to put down, public welfare reasons, but by and large, I think those court decisions say, once you've said yes once, you're now opening the doors to all future venues, subject to maybe some limitations.
Thank you. Any further questions for Mr. Ryman? Seeing none, thank you. We'll go ahead and open it up to public comment. Public comment in the audience and in line. Please feel free to come forward and fill the chairs. Is there anyone online for this section?
Madam Chairman, no one online has raised their hand with an intent to testify.
Thank you, Ms. Vaughn. Please proceed.
Thank you, Madam Chairman. My name's Carl Allred. I live here in Evanston, and there's a lot talking about today, and I mean we could go on forever. But one of the things in this area that you're talking about, and has been said, once a county approves pari-mutuel, I mean it's a whole different world from when that was approved. I remember the old statute on gambling was very, very simple. Gambling is illegal in Wyoming, except for pari-mutuel, Calcutta, and bingo, and skill game, bona fide skill games. That's how it was stated. And just quick, you mentioned skill games. I remember that used to be under TRW until they created the Gaming Commission. And I remember the meeting when that happened. But when specifically this historical racing machines, as the gaming labs say, they're slot machines. Okay, call it what you want. They're slot machines. And when pari-mutuel was approved here in Uintah County many, many, many years ago, we were talking about betting at the track and off-track betting, the simulcast off-track betting. Wasn't even the thought of the slot machines coming in. They first brought them in here to Evanston, and then Peter Michael, the Attorney General, said, they're not legal, and they had to pull them out. Then the legislature, through a lot of pressure, passed them. But the people here in Uintah County never got to say, well, we don't want slot machines. We're okay with the pari-mutuel betting at the track, betting on the off-track betting, but slot machines are a whole different world. And if you notice, right out here out on the west side of town, we're having a casino built. Well, the people in Uintah County are not in favor of that, but we can't stop it. As they said, there's what, I think he said there's 1,000 machines going in there. There's only 12,000 people in Evanston. So we're going to have this huge casino going in that the people of Evanston don't want, but we have no way to stop it. I think that, this rests with you guys, but if we give the counties the option to approve pari-mutuel betting, they should have to option these slot machines too, if they want them or if they don't. And, unfortunately, Senator Kolb ran into some of this when county commissioner. It's approved. You can't back it out. There needs to be a way for the counties to say, we don't want this. And right now we can't. So that really comes to you guys to, give us a vehicle to do that. Put it to the voters. Let the county say, hey, we're okay with the pari-mutuel betting, but we don't want the slot machines. It's a big hit on what happens in those communities. Years ago, charitable bingo was huge in Wyoming. Those of you that have been in Cheyenne, you've seen the American Legion Post 6 there. At the time that was built, that was the largest American Legion post building west of the Mississippi. That was built 100% with bingo money, with the bingo that they used to run in Cheyenne. That's gone. They had super sessions once a month that were the biggest games within states all around. Brought buses in, all that. But that was all charitable bingo money. You have Troopers Bingo up in Casper. There was a lot of these, and they did good for the communities. They weren't for-profit organizations. They were for charitable and nonprofit organizations only. So that money, but that has been killed in Wyoming with the advent of professional gambling, slot machines coming in the state, whether you want to call them the historical race machines or the skill games. The ones that they have today are slot machines. And the people that are spending their money there, it's a lot different than what it was when we first approved parimutuel betting. And I think that really it would be good if the counties could at least have a say in, we don't want this type of gambling here. So I stand for any questions.
Thank you for coming today, Mr. Allred. Any questions from the committee? Co-chair Kolb.
Thank you, Chairman. Yeah, Carl, I think to be clear, giving the voters a choice is probably important, very important. Whether they approve it or not in UNT County, I don't know. But I think you deserve it. You deserve that vote. And the majority, of course, wins under that, who showed up to vote that day, wins the question. You know, and I don't, you know, they are HHR machines. I mean, yeah, I don't disagree with your way of summarizing what they are. But I think when we have a change of the gaming vehicle, that every time there's a new change in that said choice on how we gamble, we call it basically the product. When the product changes, I think it should go to the voters, because it's not the same thing they voted for the first time. I mean, unless it's the same thing, right? But if it's not the same thing, you got kind of a bait and switch operation going. You voted for this, and then now it's not that anymore. So I don't disagree with what you said. We've always had going back and forth, you and I, over be it whatever venue we're in. But I appreciate your point of view, and if you want to add anything more to that, I'd like to hear it. Thank you, Madam Chair.
Madam Chair, Vice Chairman Kolb, I appreciate those comments, and that really comes down to what happened in Louisiana. They said, okay, this is not the same thing. And they restrict them. I remember when they first came out, you know, Arkansas, they limited them just to the live tracks. That's the only place they could have those machines. And there's a lot of different limitations that are put on. Here in Wyoming, we've just said, you know, hey, it's pretty much it's open. Once you get your foot in the door, do what you want with it. Some of the things too that you look at, I think there should be a little stronger approval with the Gaming Commission. I'll tell you, you know, one that I always liked was the Gaming Commission in the state of Washington. As a manufacturer, that was a real pain to get licensed up there. I mean, you had to provide 10 years of all your every dime that you ever brought in, that you had to open it up to them. You had to say where all the money came from. That cut down a lot of the money laundering, dirty money coming in. It was tough to get licensed. That was the toughest of all the states. And I've been licensed in all the states in gaming. But they had a lot more enforcement to the Gaming Commission. If we're going to have gambling in Wyoming, then we need to have some kind of very strict structure. You know, what it takes to get licensed as a manufacturer of this equipment. Rules that when they go to the gaming labs, whether it's GLI or Nick Farley's place, that we say this is what it has to meet to pass in our state. And they do have, every state has got different rules. So you may get something approved in one state and it won't get approved in another state. But right now, Wyoming's pretty much open. You know, if it's been approved as an HHR machine, they bring it in. But we should be looking more at these companies, look in depth at them before we give them a license to be a manufacturer or a distributor of this stuff. You know, who are these people? And look into them more before we just hand them a license. And so there's a lot of things in gaming, and it affects the people very drastically here. Thank you.
Thank you. Senator McEwen.
Thank you, Madam Chairman. How you doing, Carl?
I'm doing great, Senator.
As I've gone through this, and I'm going to ask you if you agree with me or not, but we're like, remember those old Stingray bicycles?
Mhm.
And we pointed them downhill and we got pedaling so fast that we couldn't make it go any faster. And then all of a sudden, that front wheel started wobbling. It seems like we're there with this right now. I'm not even sure what authorizes a skill game. We got, as our wonderful county commissioner pointed out, 2 sentences. You can do this, and you have to vote on it. But we can't even deny permits. So would you agree that we've kind of got ourselves into a little bit of a mess here?
Madam Chairman, Senator McKeown, I do agree with that. I think we, jumped into it. I remember when I first brought skill games into Wyoming, I would take them to the county attorney and we would have to demonstrate, number one, they are a bona fide skill game, which means I have to prove that I can win every time. And, and then it was up to them whether or not they wanted to try to seize them, take them to court or whatever. But today, we go into this and you see this across the entire country, the proliferation of gambling. And it's really hurt a lot. Back in the day when you had Las Vegas and Atlantic City, those were destinations. And you would save up, okay, I've got money set aside for this trip to Las Vegas. We're going to go and you're going to spend some money there. But when the gambling is around the corner, that's when you're going in there and you're spending your rent money, your food money, you get on public assistance. And every single state that has expanded gaming has increased the social cost to the state, whether it's affordable housing, food stamps, healthcare. And I mean, no mistake, gaming is huge. It's a big business and there's a lot of money to be made. But generally it hits those people who can least afford it. When you walk into one of these casinos in Cheyenne or Gillette or here in Evanston, you don't see the guys who have the money in the community sitting down there playing a slot machine. You see the middle class and lower middle class people in there. And they're spending money that sometimes, I mean, to be honest, I play the lottery, but I got a set amount that I buy tickets with, and that's it. That's disposable income. When it's almost $1 billion on the Powerball, I don't go drop $1,000 on tickets, but I have seen it happen right here in Evanston. People from Utah come up and they'll buy, $500, $600 worth of tickets. So as we do that, I mean, gambling is a legitimate business. But somehow we have to balance the gambling with what it cost us at the state, what it costs the communities. And just flooding it hurts us. And so, Senator, I do agree with you. The front wheels are wobbling. And so we need to try to get it back on track, rein it in a little bit.
Representative Johnson.
Thank you, Madam Chairman. Carl, it's good to see you. And I would just like to say that I do think that we need to allow citizens to petition and cut down gambling or forbid it in your communities. I think that would maybe also allow these gambling establishments to be good neighbors. It would cost them to fight a petition, but maybe they could have more community involvement and use some of their money to improve the community. I mean, I think that just allowing the citizens to petition and to remove gambling in their city or their county would be a big benefit. And your comments, Carl. Thanks to see you. Good to see you.
Thanks, Madam Chairman, Representative. I agree with that. You know, one town may want them and the next doesn't. You know, we go back, like I say, years back when we had the charitable bingo, the state just had an exemption. It was legal. But the municipalities, for example, Cheyenne had a fantastic ordinance on bingo. You know, before you could play the session, you had to show that you had the money to pay out every single one of those prizes before you even drew the first ball. So the municipalities were allowed to make ordinances to regulate that because the state had it open there. But as has been said, the counties can't restrict it once it's been approved in some form, and the municipalities don't have a word in it. So I think really that, you know, this is a different world. So we should at least be able to have the opportunity to say, okay, maybe we want the pari-mutuel at the track and even a simulcast, but we don't want machines. Or maybe we don't want the simulcast, you know, but that should be put back in the hands of the people. And again, that rests with you guys if you can bring that in. Thank you.
Thank you. Co-Chair Cole.
Thank you, Madam Chairman. Well, Carl, you bring up an interesting conundrum. So I'd like to hear your perspective on this. I thought you were always a person of personal freedoms and personal choices. Now we got folks running off and gambling, which they probably don't have the money. You know, honestly, they don't, but they're addicted to it or they really like it or whatever be the level of their interest. Where do you draw the line on people doing things that you knowingly know? I mean, you're not you're a smart fella. You understand the reality of the world. Where do you draw the line on taking away people's personal freedom to make mistakes that maybe you wouldn't have made? I'll call it a mistake because I wouldn't do it. But where do you draw that line? I mean, because now you want the government to take over in some form or fashion to say, nope, you're Jim, you're addicted to gaming and you shouldn't be doing this anymore. And I know more than you do. How do you just make that distinction, Carl? From a man with your background and beliefs, I'm curious to find out where you lie on this.
Madam Chairman, Senator Kolb, you're right. It is a tough thing to try to figure out where you're going to put that line. But at the same thing, do we allow prostitution? Do we allow cocaine? You know, there are certain things, and that's where I'm saying if we put it to the vote of the people in that county, overwhelmingly do the people in this county want it? The people in Laramie may want it. People here may not. But if we put it to the vote of the people and we give them that option, when it comes down to public policy, there are certain things. You know, there's certain people that, you know, sometimes they use the phrase they're wasting oxygen. That doesn't give me the right to stop them from doing that. So we do have community standards. We have community morals and ethics that go by that community. We, like I said, we don't allow prostitution because the downsides of that, drug addiction. There are certain things that for the overall, we do put some side rails in there. And again, that's why I'm advocating that we give it to the vote of the people in that community. Let the community decide. Now, that doesn't mean over in Sweetwater County, you guys could have it. And if somebody wanted to drive across the county line to go do it, you know, in Kentucky, they got dry counties and non-dry, and you just drive across the county line. So, but that community should have a voice in what we want in our community. That doesn't mean you have to live here in Evanston. That doesn't mean you can't go to Sweetwater or, you know, whichever county you want. but the community overall, when there are detrimental effects, they should have a voice in saying, we really don't want that here. You can have it. You can go to Las Vegas all day long, except they're tearing the casinos down there. But you can go somewhere if that's what you want to do. It's not that it's illegal. It's just that our community standards may not want it. So you're right. It is a tough line where you draw that. But I do think that putting a voice to the people, I think, is a step in the right direction.
Thank you for your clarifying remarks. I just have one quick question for you. You come as a person of the community. How do you feel about the live racetrack here in town?
Madam Chairman, I think the live racetrack is great. It only runs a couple weekends. But I do think it brings in people. A lot of the horses come in from Utah. Utah's got a lot of great racing horses, quarter horses down there, but they have no place to run them because they don't have parimutuel. We get them from Idaho. We get them from a lot of places. But the live track is a lot different. Even the off-track betting, the simulcast, there's a whole different feel to that than there is playing the slot machines. But I like the live horse race. I think it's good. So, and that's what the people here voted on.
Thank you for those clarifying remarks. Any further questions for Mr. Allred? Seeing none. Any further public comment online or in the room? Welcome. Please state your name.
Turn the mic off.
Thank you, Chairman Lane. I am not here in my official capacity right now. I'm here as a citizen of Uintah County. My name is Loretta Callis. The reason I make that distinction is because I am our elected county attorney. I am the president of Waco and I'm the vice president of my association. So I want to make it clear I'm speaking for myself, not for any of those capacities and certainly not for my commissioners. I respect the former Secretary of State very much, but I felt compelled to speak to you because I strongly disagree with the statements he just made to this committee. I do believe that if a vote was presented to the people of Uintah County, we would overwhelmingly pass all of the current proceedings that are in place, including skilled-based gaming and HHR. These businesses not only provide for example, you ask about the track. The Wyoming Downs every year, it doesn't run for a couple weeks. I believe it's about 11 weeks this year. It's for 2.5 months. And we have over 800 horses, if I recall correctly from my last number, that come into our community. They stay here for months. They're trainers, they're jockeys. They bring in money to our economy. They support our local businesses. And we do have a number of individuals that travel from across the state in Utah and Colorado to come attend those races. That certainly is just for the summertime, but throughout the year, anytime that you went to any of our establishments that have the off-track betting or the skill-based games, you will see individuals from out of state actively participating and providing to our community. These are invaluable benefits to our local businesses. And the HHRs, in some ways, I challenge you to not be contradictory. You are saying you want to support horse racing, that you want to support the expansion of horse racing in the state of Wyoming. Those HHR machines go to help the Wyoming bred charities. That's where a lot of that money goes, to support those local breeders. And so eliminating HHR and those games truly would have an effect in relation to those matters. I also have to say that I strongly disagree that there are only people who shouldn't be gambling in those establishments. You will find business owners and oil operators and other individuals in any of our local businesses at any given day, and it is their choice for each and every person to facilitate their own balances, their own finances, and I strongly discourage any legislation that would dictate how an individual utilizes their own income. They work for that money. They earn that money. They should spend it any way they choose. This is a highly regulated and tested industry where these machines are tested on a regular basis. I will tell you that the only criminal investigation that I have seen is not related to the operation of the machines. It is actually related to a separate issue. And again, I'm not here in my professional capacity, but that involved the relay of money to the proper sources. It did not involve misuse of those machines. And I would stress that if you are going to say that gambling has an ill effect on the community, you use objective data. We have several, Evanston is blessed. We have the Wyoming State Hospital. We have many mental health facilities in our county. And in those facilities, I stress that you should ask them, how many gambling addictions do you treat in Uinta County? And I would highly doubt that it's more than 5%. That is not the major issue and societal concern that I am seeing in my community. We are not hurting our communities by having these machines. We are benefiting and growing businesses. We are supporting our local economy, and we're encouraging small business and this horse industry. And I would ask you, in anything that you do, certainly my entire life has been founded on we the people. That is something that I've taken an oath of many, many times. And so I'm not discouraging any voting process at any time, but certainly use objective data in any legislation that you provide, please.
Thank you. Is there any questions from the committee? I'm sorry, I missed your last name, Miss Loretta.
Callis, ma'am.
Callis. Thank you. Is
Madam
there
Chairman?
any questions? Representative Johnson.
Yes, thank you, Madam Chairman. You addressed mental health issues, and that's coming up tomorrow. I believe we're going to discuss that. It's kind of like the red flag law, gun law. We can't have somebody tell you you can't gamble. But there is a mental health issue to this situation, and it does affect a few people. I don't think it's a majority. I do believe that it might be 5%. But what suggestions do you have to use that to help those people that do have that addiction? If you could comment, and we're looking for a way to improve Wyoming. So any comment you have, we'd be thankful for. Thank you.
Chairman Lane, I believe it was Representative Johnson. Is that correct? I'm sorry, I'm better with name tags and he doesn't have one. In relation to those matters, and I am here actually in my official capacity, we're going to try to have a member of our County Attorneys Association at every meeting this summer, and I'm happy to address that. I do have special knowledge related to mental health concerns, I believe, because of the fact that Evanston, we are truly in the heart of a lot of your Title 25 and Title 7 issues that you're addressing, capacity, follow-up care, and other issues. This topic today related to gambling, I will note, is not an issue that we have any substantial issues with. I've been the elected county attorney here since 2015. So this is my full 10th year in office. And I cannot recall a single Title 25, for example, that we would have addressed related to gambling. In relation to theft cases, for example, I don't see that. These are the ills that we see in society. And we get them for certainly drugs. We have, unfortunately, way too many controlled substances in our county and other issues. And the use of those controlled substances accelerate and aggravate mental health issues substantially. And so how to help those, I do believe you have studies that you have asked to be conducted in relation to this proceeding for gambling. There are resources, which I listened to your last committee meeting, and I was shocked to hear that Uinta County does not elect to receive any of the funding that you have for those different funds to address. And I want to make sure you have two different terms. One's responsible gaming and the other is the bad one. Sorry. Problematic gambling. Thank you, Jeremiah. We don't see a lot of problems with problematic gambling, but we certainly have some of the largest resources for gambling in the state of Wyoming here in Uinta County. So that surprised me when we don't take those funds. I imagine that If I spoke to our county clerk, it's likely that the portion that would come to UNT County is so small that administering that grant is probably problematic. Because I do know that we declined a number of grants for that purpose. Maybe making those funds more directly relatable and finding a connection with the Department of Health for like their behavioral health design or something to get those directly into the community without that administration, maybe that would be an idea.
Thank you for those thoughts. Any follow-up? Any further questions? Co-Chair Cole.
Thank you, Madam Chair. With those 1,000 new machines coming in, maybe you're going to have a better chance to get grant funding at that point. I would think it's going to greatly improve your chances.
Chairman Cole, that actually does remind me, I did want to note that all of our, the different businesses, 307 Racing, Wyoming Racing and the other programs, they do come and talk to our commissioners each and every time. We've been well aware of the project that is occurring there on the I-80 off-ramp there, the first exit from Utah for, I believe, 2 years. And so that was communicated with our commissioner. That is part of the city boundaries. So just to be clear, the city of Evanston would have had to approve that project through their planning and zoning. So to say the city and the county does not have any involvement, we may not have the control that you guys are seeking to provide. And certainly I will defer to Jeremiah Riemann related to that. But we certainly have knowledge and have provided letters of support to the Gaming Commission for that facility.
Thank you for those remarks. Any further questions? Any further public comment? Welcome.
Thank you, Madam Chair. This microphone was on. I know I'm keeping everyone, absent someone else wanting to testify for lunch, so I'll try to be brief. My name is Affie Ellis, representing Cowboy Racing. A few points. Mr. Ryman mentioned that Teton County is one of those counties that has approved simulcasting, but currently doesn't have simulcasting. There are 2 others. Weston County had approved it in the 80s and Platte County. I asked the Gaming Commission if they had the date of when, and they were unable to find that answer. So total 10 counties that don't have simulcasting right now, or HHR machines. I also just want to emphasize the point that Ms. Ravalli made when she presented her memo, and she's spot on. She made the point that, some of these other jurisdictions and how they tackle regulation and limits on gaming, they do so because there isn't without a statewide objective of why they allowed those machines in the first place. And so I think that's the delicate balance we want to continue to emphasize, is Wyoming had a clear objective. We want to reinvigorate a dormant, dead live horse racing activity or status is not having live horse racing. So that's the intention. And, as someone who is working with a company that has built a racetrack, I don't think they would have built the racetrack if they weren't allowed sources of gaming revenue. And so that begs the question, though, of how did we get in this mess? How do we get out of it? And so, we talked about, well, let's just leave it up to the locals. Let's just have an election. I want to draw your attention to Louisiana. I've been doing a lot of reading and research on how things have worked in other states. And there was a particularly ugly instance in Louisiana where there was an established operator who saw some competition coming in at a neighboring parish. And in Louisiana, they require a local election. And so there was litigation about whether or not they could even have the election. They passed that hurdle, the new operator or proposed operator. So it goes to election. Their competitor, a gaming company, used gaming money to create an anti-gambling group. And they started running commercials with children sitting in the laps of parents playing video poker machines or whatever the gaming device was. And they said, oh, we can't have more gambling, which I think is a very fair perspective, but not when it's funded by a pro-gambling entity or a gambling entity. So I just want to urge caution that I don't think a good solution is to see who can run a better campaign, who can arm, or fill a room with people with more pitchforks, who can yell loudest at the commissioners, who can yell the loudest at the public. I think we see that a lot already, and I don't think that's thoughtful legislation. Perhaps what we should have done is when we authorized these machines in 2013, we should have said, if you want these, historic horse racing machines, you have to have county approval. We didn't do that. So my caution is, whatever we do going forward, as long as you treat all the operators equally, that's what we're looking for. It jumps the gun a little bit, our concern about moratoriums. It rewards those who built these empires and ices out new competition, new entities like Cowboy Racing that are trying to bring new live horse racing opportunity to the state of Wyoming. So we can talk more about that, but I just want to urge caution when it comes to saying, let's just let the locals handle it. We'll just have an election and it'll be fine. I think you've got to be careful what you wish for and think that through a little bit more carefully. The last comment I'd made is we've talked a little bit about problem gambling and gambling addiction. If you listen to the debate when the legislature authorized HHR machines in 2013, there were amendments on the House side that would have dictated that more money be dedicated toward addressing those issues. But at the time, one of the former House members, I believe it was Representative Greer, said, well, that's a local control issue. The locals will be making so much money off their gaming revenue. If they want it to go to problem gaming or responsible gambling or whatever, they can set up programs and use their gaming revenue that they've got coming in. That's a local control issue. So I've been in your shoes, and I know we say we like local control until we don't like local control. Local control means this until it means that. So I just wanted to offer that one perspective. Not saying I agree with it one way or another, but just some history for you. Happy to answer any questions.
Thank you, Ms. Ellis. Any questions? No. Any further public comment online or in the room? Representative Johnson.
I would just like to reinforce what Affy just said to us, that we have to be careful we do not create a monopoly or a duopoly. I mean, we have to treat everybody equally, and that's our job here today. I think I just wanted to throw that out.
Thank you for those remarks. Any further public comment? We'll go ahead and close public comment here. We'll go ahead and recess for lunch. We'll return at 2 o'clock.